Thank you. Good afternoon, all. This application hearing is in the matter of CFI 070-2022 and is being held by way of video conference before Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by KBH Limited. Lead counsel is Ms. Bushra Ahmed. The respondents are represented by Davidsons & Co. Lead counsel is Mr. Andrew Trother. Thank you, Your Lordship.
Thank you. Yes, Ms. Ahmed, it's your application. You can take it. I've read sometimes somewhat cursorily the various affidavits and so on. I'm not interested in going into the bad temper between the parties about what they have or haven't or should have done. I want to know your submissions on the actual application.
I'm grateful, Your Lordship, for that indication. I appear on behalf of the claimant, Mr. Paramjit, Kahlon, and my learned friend, Mr. Trotter, appears on behalf of the defendants. And the application notice requires the defendants to comply with their disclosure obligations. And in that context, the purpose behind the application is rather significant when one reads Mr. Swangard's witness statement. And if I can quickly draw Your Lordship's attention to that, which gives really a flavour of the scale and significance of the defendant's disclosure obligations and what's outstanding. And if I may invite you to turn up page 65, Your Lordship, it's paragraphs 10 to 11.
Hold on 1 second. I've now lost it. Right. Sorry, give me a second. What
Page 65.
Yep.
This is Mr. Swangard's witness statement. And I'd like to draw Your Lordship's attention to paragraph 10 and 11. And the reason being is, in the context of this application, it just gives a flavour of where we are with production, the outstanding matters, and what, if anything, might be the impact. So, Your Lordship, if I may just invite you to read paragraphs 10 and 11.
Sorry, am I reading the right thing? This is the page what of what?
65 of the bundle.
Of the whole bundle, yeah.
Yes.
Give me a second. Yep. Paragraphs 10 and 11.
Paragraphs 10 and 11. It's Mr.
Under the heading, the defendant's document production.
Yes, and this is Mr. Swangard's witness statement on behalf of the defendants in response to the application.
Yep.
And Your Lordship, the reason why I invite you to read these paragraphs in introducing my application today is because, Your Lordship, there are 3 key questions arising from this application today, and those are, as we say, as follows. Firstly, should the court grant the document production order sought by the claimant to ensure that those specific requests are fully met? And should the court order that production as set out in the draft order within 7 days of today? And just in that context, Your Lordship, the defendants accept that they are able to, and that's at 11.3 of Mr. Swangard's witness statement, they are able to meet that timetable, and they indicate as such. So that's the first question, Your Lordship. The second question, what, if any, impact will the outstanding production and the requested orders have on the trial timetable? We say not much, but we would like to hear from the defendant on that, and whether or not any impact per se can be impacted. And the third question is a question of cost, which Your Lordship won't, which I'll deal with at the end of the application, if I may. And so, Your Lordship, in the context of those questions, my oral submissions will proceed on the following agenda items. The first agenda item is to take Your Lordship to the order that's being sought in this application.
Mm-hmm.
Agenda item 2 will deal very briefly with the background of the application. And I hear what your lordship says about not wanting to go through in detail the background. Number 3, agenda item will take you through the disclosure requests and the substance of the application and the request that the claimant is making, as well as dealing with my learned friend's objections and the defendant's objections to those requests.
Why am I interested today in the claims that sorry, did you say that the claims the defendant are making?
No, the claimant's making. The request that the claimant is making. I beg your pardon if I said the defendant. So the request that the claimant is making and dealing with the defendant's objections to those requests. And in that context, your lordship, I'll invite you to look at the pleadings as to determine why the requests are relevant, and then of course deal with my defendant's objections. And then your lordship, agenda item 4 will address the other aspects of the application, and that is inspection and disclosure statement. Agenda item number 5, I have here that I will be dealing with my learned friend's skeleton argument, but it may be that I don't need to do that because I will address that in agenda item 3. And then finally, your lordship, if at that juncture you want to hear from me about costs, I'll address your lordship on costs. And so, your lordship,
we'll deal with costs at the end of the hearing.
I'm grateful, your lordship. Can I then deal with agenda item 1 and the order and the relief sought in this application? The draft order is at pages 12 and 13 of the bundle. And page 13 is the order sought, and it's really divided into 3 primary components. The first component is paragraph 1A and B. And what we say about that is that 1A are those requests arising from the reformulated request to produce. These were originally served on the 20th of August 2024. They were subsequently narrowed and reformulated, taking into account the defendant's objections, and served on the 6th of November. I beg your pardon. Paragraph 1B refers to the request for specific production, and this category of documents we call the DMCC documents seeks disclosure of financial, employee and regulatory records. This is, we say, to address the operational status and is an extension of compromise request 10 and 12 of the reformulated RTP that was served on the 6th of November. Paragraph 1C then deals with documents related to Ms. Katrina Slobodjanic, and I'm going to call those KS documents in short form. And these relate to a version of an email and a WhatsApp that was included in the email. To some extent, this has been now dealt with. However, the claimant still seeks the inspection of the original documents as well as the devices on which they were found. So that's still a live issue today. And then that deals with D and E, and then we have paragraph 1F, and that is...
Sorry, just while we're on it, what is the particular importance of this WhatsApp chat?
Your Lordship, paragraph 75A1 and 75A2 of the amended defence, the defendants call into question the claimant's conduct. And to that extent, it's assumed, not that it's pleaded, but it's assumed that the email and the WhatsApp chat go to the conduct of the defendant. And so, your Lordship, whilst this email has been disclosed, the metadata hadn't been disclosed and the claimant was asking for that. Now that has been provided in a native format. Notwithstanding that, the claimant still seeks inspection of this email and the devices on which it was found, given that the defendants rely on it in support of what we assume is paragraph 75A 1 and 2 of their defence.
Okay. Yep.
And your Lordship, so that deals with 1C, D and E, and then we have 1F, which is seeking a disclosure statement verified by a statement of truth to confirm the scope and adequacy of the searches conducted by the defendant. Paragraph 2 of the order is no longer alive because the request for information was provided on the 24th of December. And then paragraph 3 deals with costs. So your Lordship, that's the order that the claimant seeks today. Your Lordship, in terms of agenda item 2, this was to deal with the background to the application, because we say that it's relevant to the issue of how the defendants have conducted themselves, possibly relevant to the issue of cost. Well, I say possibly, but definitely relevant to the issue of costs. And also, your Lordship, I want to take it very quickly and simply the relevant parts of the correspondence. Now, your Lordship, before I take you there, attached to Mr. D.K. Singh's witness statement, a table setting out the relevant correspondence. And your Lordship, if I may take you to that. That's at page 121. I beg your pardon, it's attached to Mr. D.K. Singh's reply witness statement dated the 3rd of January.
Still page 121?
Yes.
My 121 is blank. You want Mr. Singh's third affidavit, third witness statement?
Yes, please. Your Lordship, I'm working off a paper copy. I had troubles accessing the electronic.
Third
Lordship,
witness statement.
Yes, it's the third witness statement. Starts at page 104.
Don't worry about those pages. This is outside the bundle. So, what paragraph?
So, your Lordship, it's attached.
I've got the document. I just want to know what paragraph I'm looking for.
You're looking for the paragraph that refers to the annex. Sorry.
Yes, they have the paragraphs have numbers. What number paragraph?
Yes, I've got an internal number in 18. What paragraph? Your Lordship, I'll find the reference. It's an annex to that witness statement, and I will find the reference to it within that witness statement.
So annex to.
It's an annex to.
1.
I beg your pardon. It's annex 1 to Mr. D.K. Singh's third witness statement, and it sets out a table with the correspondence and the statements made in relation to document production. And it may be quite helpful, your Lordship, to have that reference there in relation to the communications between the parties, especially when it comes to looking at how we got to this application. And your Lordship, just to give you procedural context,
I haven't got it yet. Because it came later than the bundle was put together. I haven't got that.
Well, your Lordship, would you like us to send it to the registry separately after the hearing?
That's the last thing I want. I just want to find it now so I can follow what you're submitting. You want Mr. Singh's third witness statement, but you want the annex to it. Is that right?
Your Lordship, the annex sets out the communications between the parties, and if you don't have it, I can save time and very quickly refer you to the documents that annex refers to.
Okay.
And maybe that might be the simpler and quicker way to do it. And your Lordship, you will recall that this matter was before you in October of last year, where there were significant delays in the timetable. And just by way of quick summary, there was an initial case management order issued on the 13th of May. Requests to produce the deadline for the request to produce was the 19th of August. However, the claimant served it on the 20th of August because the day before the defendants changed their legal representation. And at that time, the requests comprised 16 requests. Now, under that order, the document production was supposed to be completed by the 30th of September, and we lost about 3 months before we came back to the court. But in the context of the kind of procedural timetable, the defendant filed their objections on the 27th of September, and the red phone schedule, which gives a complete picture, is at page 368 of the bundle.
Yeah, yeah.
And I take you to this because this comprises, or rather gives a picture of what's been going on in terms of the request to produce any objections and the reformulated requests.
Mm-hmm.
So, Your Lordship, page 368, it's the first page, and paragraphs 1 to 6 are the preamble that sets out the background. So, refers to the case management order of His Excellency Justice Nasser al-Nasser, request to produce served on the defendants on the 20th, objections in paragraph 2, referred to in paragraph 2 on the 27th. And it sets out in summary how the defendants responded to the request to produce, and that was they only accepted one request, rejected 3 outright, and provided narrow reformulations of 10. And that's at paragraph 3. Paragraph 4 describes what the claimant then attempted to do in advancing a sensible compromise, formed a series of reformulated requests, and that's the subject matter of this application, and invited the defendants at paragraph 5 to consider the or paragraph 5 and 6 to consider the claimant's reformulated requests. Page 369 of the document then refers to the document, the definitions as to what the document, communications and records are that are referred to in the RTP. And Your Lordship, it's page 370 where the requests start.
Yeah.
And in terms of just going through the columns and explaining what they are, the first column is the original request that was made on the 20th of August.
Yeah.
The second column sets out the reasons for the claimant's request as to relevance and materiality.
Yeah.
The third column provides the defendant's objections to those requests as served on the 27th of September.
Mm-hmm.
And the fourth column is the claimant's response to those objections, and provide for the reformulated, or what's referred to as the claimant's reformulated request to produce, which was served on the 6th of November. And you can see there the proposals made as to the compromise request and the analysis there. And it may be, Your Lordship, if you're able to, from the software that you're working off, pull up document at page 57.
Of the same bundle.
Of the same bundle.
Okay, so I lose this one.
Your Lordship, if you can keep both open, that would be quite helpful.
No, I can't.
Okay. Well,
what is 50?
Annex 1. Annex 1 is a representation of these requests to produce, but I've been working off Annex 1 because it's just a far easier document to navigate. But I let me just deal with the RTP.
I've got it. I've got Annex 1.
And that's at page 57.
Yeah.
So, Your Lordship, what this document does, it sets out the requests as lifted from the claimant's reformulated RTP. It sets out the request description and then the analysis of the defendant's production. And so once we've dealt with the request to produce, Your Lordship, I'll be dealing with Annex 1. But coming back to the request to produce at page 370, so the original request 1 was reformulated, and that's in the 4th column. The analysis was set out as to why these are relevant underneath. And the point is there in terms of the 4th column, it sought to consider or reconsider the objections made by the defendant and streamline the original request that had been made.
Yep.
And an example of that is the second request at page 371.
Yeah.
So this is now termed compromise request 2. In the 4th column, you can see how the claimant has compromised his original request by streamlining it into 2 parts. 1A and B, and then 2 through to 8. And just very quickly to explain what 2 to 8 are. 2 to 8 are all of those agreements that are part of the factual matrix of this claim, Your Lordship. And then beneath that, it narrows the scope in terms of the custodians of those, and identifies those individuals' devices that should be searched, provides the analysis. And Your Lordship, just at the bottom, my font is very small, but what it says is, in contrast, against compromise request consolidates the scope of the original request 2 with request 3, 5, 6, 7, 8, and 11 into a single streamlined category. In other words, compromise request 2 incorporated those original requests made in the original RTP, numbers 2, 3, 5, 6, 7, 8, and 11.
Yeah.
Over the page 373, original request 3, compromise into request 2. That's in the 4th column. 374.
So three disappears then, does it?
So 3 disappears.
Yeah.
Original request 4 at page 374. That's compromised with a more streamlined request in the 4th column, and that becomes compromise request 4.
Yeah.
Again, on that page 5, request 5, original request 5 disappears because it's now formed part of compromise request 2.
Yeah.
Page 375, original request 6 again disappears because it becomes part of compromise request 2.
Yeah.
Page 376, original request 7 again disappears. It's amalgamated into compromise request 2.
Yeah.
Page 377, original request 8 disappears, becomes part of compromise request 2.
Yeah.
Page 378, original request 9 is repeated. So there is no compromise in relation to this request, and the reason why is set out there below it.
Yeah.
That's called repeated original request 9. Over the page 379, original request 10 becomes compromise request 10, and that's, as your Lordship can see, is streamlined and narrowed considerably.
Yeah.
Again, analysis underneath there. Original, on the same page, original request 11 is incorporated into compromise request 2.
So that disappears.
That disappears. Original request 12 at page 380 becomes compromise request 12, and it's a reformulated, revised request, which is cleaner and more streamlined. And the analysis is underneath at 381 as to the reason for the request. Original request 13, it's at page 381, is repeated, and therefore there is no reformulation there. And that is because this deals with the LTIP issues and the quantum issues. And therefore that's repeated. And also just to add, these are the documents that the expert says will be necessary and relevant to his expert report, and therefore that is repeated. Page 38.
Can you remind me, sorry, the hearing fixed for March through to May, that is liability only, or is it quantum as well?
It's liability and quantum. And in your case management order that was issued in October, your lordship provided 4 expert reports and on 3 discrete issues.
Yes.
Your lordship, would you like me to take you to that case management order?
Yeah, I remember the order. I just couldn't remember because originally it was going to be split between liability and quantum.
That's right.
Right. Okay.
Your lordship, page 382. That's original request 14. And your lordship, the defendant said that they did not object to this request, and therefore it was noted. But the reason why it forms part of this application, because the claimant says that there are significant gaps in the disclosure, the defendant's only having disclosed 4 documents relevant to this request.
Yeah.
And your lordship, 15 and 16 I can take together. That's at page 382 and 383. 15, the defendants provided a reformulation and therefore that was agreed by the claimant, and that's the only reformulation that the claimant agreed. And request 16 disappeared because that then formed part of or was incorporated into request 15, and that reformulation was agreed.
Yeah.
And your lordship, if I may, having done that, sort of gone through that, if I may take you then to the annex that I'm working from, because, and that's at page 657.
57.
57, and this is the annex to the draft order.
Well, if you wait a second, I printed that out the other day. The annex to the draft order is at 17, isn't it?
Yes, that's schedule. Yes, your lordship, that's schedule A to the draft order. But your lordship, when I was working through this document, I found it quite dense. It's a mirror image of the request to produce that I've just taken you to, bar the addition of the last column, which is reasons for this request.
Right, so what do you want me to look at?
But for ease of reference, your lordship, I've been working off Annex 1, which is at page 57.
Is that the one I haven't got?
This is a different one. This is the, I beg your pardon, this is, the one that you didn't have was Annex to DK Singh's reply witness statement. This is an annex to his.
Yeah. Okay, I've got this, yeah.
And your lordship, the reason why I'm inviting you to look at this, because what this sets out in the first column are those compromise requests, as I've just invited your lordship to consider.
Yeah.
The second column provides the description of the request. And your lordship, the third column is an analysis of those documents that we say are responsive to the request, rather the number of documents and what's missing.
Right.
And your lordship, Annex 1, which is at page 57, as well as Schedule A of the order, really sets out the claimant's position in terms of the purpose and reason for this application.
Right.
In tabular form.
If I'm looking at 2 documents together, should I be looking at the page 57 and also the annex to the order?
Yes, your lordship.
Is that what I should be looking at?
Yes, your lordship. And your lordship, the point of taking you to...
Wait a second. Right. Okay. Schedule A to the draft order.
Yes, your lordship.
Right. It's not very easy to look at them both on screen together.
In which case, your lordship, I'd invite you to look at Annex 1, because I'll be making submissions in relation to the relevance and the defendant's objections. So it may be my oral submissions are easier to follow rather than looking at the table.
Right.
And Your Lordship, the reason why I've taken you to the claimant's reformulated RTP is that, contrary to the defendant's assertions, where they say that this is a patchwork of demands, in my submission, what Your Lordship can see is that the claimant has considered the objections of the defendants and had a careful and well thought out approach to production, giving the defendants multiple opportunities to engage constructively. That was to avoid coming back to court. So, Your Lordship, when Mr. Swangard says in his witness statement that the defendants progressed their document production based on their own reformulated requests, and when my learned friend in his skeleton argument refers to dealing with their own reformulated requests, that's not the approach that the claimants were expecting, nor was that the impression given to the claimants. All along, Your Lordship, the impression that was given to the claimants was that the defendants were engaging with the claimant's reformulated RTP. And so, Your Lordship, the claimant was proceeding on the basis that the documents that would be produced in the responsive production would be in response to the claimant's reformulated RTP, which I've just taken you to. And Your Lordship, in that context, may I invite you to turn at page 458. And Your Lordship, the claimant's reformulated RTP that you've just seen was served on the 6th of November.
Yeah.
And this is a letter responding to that by Davidson and Co. And it's paragraph 4, Your Lordship, which refers to the defendants willing to engage constructively, as would be clearly preferable. They can't provide feedback, but they will consider the compromise requests, but not by the date stipulated by us, which was, if I may go back to, was the 13th of November. And so, Your Lordship, the defendants suggest engagement, but what they didn't do is provide any concrete timelines or proposals. And we say that that really gave the impression, or the wrong impression, that the defendants were dealing with this, when in fact they weren't. Your Lordship, the first tranche of disclosure was given on the 15th of November. But Your Lordship, if I can invite you to turn up page 460. And Your Lordship, the disclosure was given out of time, but before it was given, the defendants at 4:30, half an hour after disclosure was supposed to be given, raised confidentiality concerns. And Your Lordship, this letter at 4:60, dated the 15th of November, which was the date that Your Lordship ordered for disclosure to be given, was a first tranche. And Your Lordship, in there at paragraph 2, the defendants gave the impression that they would be producing highly confidential and commercially sensitive financial information with regards to these 4 categories at 2A, current and former employees of our clients and other entities within the GFG Alliance. And that GFG Alliance point is important because that, we say, relates to one of the requests that we're making, the first compromise request. 2B, information relating to business affairs, customers, clients, suppliers, market opportunities, operations, processes, and so forth. 2C, financial and business performance data. 2D, any other information considered confidential or proprietary. And Your Lordship, this letter received at 4:30 gave the impression that it was just confidentiality issues that were a bar to disclosure, and that the responsive disclosure would contain documents related to all of these categories set out at 2A, B, C, and D. However, unfortunately, that wasn't the case once we received the responsive disclosure. But in terms of KBH's response to this, and Your Lordship, before I move on, 461, page 461, paragraph 6, having sat on this for months, The defendants then seek a response, having sent a letter at 4:30, seek a response by 5 p.m. on the 15th of November, the day that responsive disclosure was supposed to be given. That's at paragraph 6 at 461. At 464, we see the claimant's reply written by KBH.
Yeah.
Which, paragraph 2, your letters received by this firm at 4:28, almost half an hour after the mandated deadline. And paragraph 3, our client is content to agree to the proposals of 4A to C, 4C, as long as there's reciprocation. And your lordship, the point being that the claimant was wanting to progress for production and wanted to engage constructively with the defendants. Page 462, your lordship, was a bit of a blow. Oh, I beg your pardon?
You say 462?
Yes.
Right.
Page 462 was the covering letter dated the 15th of November serving the production, which, your lordship, quite frankly, was a bit of a blow considering what the defendants had implied would be part of the responsive production. And what they say is that paragraph 3, unfortunately, it hasn't been possible to identify, collect, process and review the entirety of responsive production. Overarching difficulties of volume of material. Paragraph 4, the documents produced today represent a significant proportion. There will be a further tranche. Paragraph 5, consider it unnecessary and disproportionate for your client to apply for a production order. And the later parts of the letter explaining that production will be given in tranches. Now, unfortunately, what they didn't do in that letter is clarify whether or not any of the significant proportion that they spoke about was responsive to the claimant's reformulated RTP. They also don't provide a disclosure statement, therefore the claimant not being able to assess whether or not disclosure has been properly met. And it was the first time on the 15th of November, the day that the deadline had to be met, that the defendants disclosed to the claimant that they haven't completed their disclosure and they're still reviewing the documents. Page 465, your lordship, is, I beg your pardon, page 466 is a response, KBH's response to this letter.
Yeah.
And at paragraph 2, they say, we don't accept there's insufficient time for your clients to undertake document production. This is particularly so given that your clients disclosed just over 1,000 documents, and Mishcon, a global law firm with a sophisticated e-discovery team, appears to have been heavily involved in this exercise. And your lordship, you'll recall from Mr. Swangard's witness statement in paragraphs 10 and 11 that I took you to, that not only are Mishcon engaged in the disclosure exercise, but there is a third-party external consultant as well, 3CI.
Yeah.
Paragraph 5 is the claimant's position that they're keen to avoid an application of document production order. However, as your clients are aware, the timetable for this case affords little room for further delay. And in that regard, our client would make an application if those documents identified in your second letter are not promptly provided. And so, your lordship, there is a further letter on that date at page 465. And this is in relation to the claimant's reformulated RTP, which paragraph 2, we're grateful that your clients are willing to engage constructively with the compromise requests. Your clients have now had a week and a half to consider the compromise request, and in light of the various fast approaching court mandated deadlines, we request you to respond to our client's proposal by no later than Tuesday, the 19th of November 2024. So again, that's a second letter chasing response to the claimant's reformulated RTP. Page 468 is the email serving the second tranche of disclosure. Which consisted of just under 1,000 documents, 728 documents to be precise. Page 469 is a letter again written by KVH on the 26th of November, which is a third letter seeking a response to its reformulated RTP. Paragraph 2, we are yet to receive your client's agreement or alternatively comments on our client's compromise requests, despite repeated requests and your assertion that your clients are willing to engage constructively. timetable affords no further room for delay. Your client's refusal to cooperate already places in jeopardy our client's ability to serve his witness statement on the 20th of December and further delay.
Why is that? Why does production of documents affect the ability to serve a witness statement? A witness will only speak in his statement to what he knows about. It doesn't require documents from the other side.
Your Lordship, the reason why it would hinder him is because it would be inappropriate for him to put forward a witness statement if there are documents out there that he hasn't had the opportunity to consider or reflect, or if there are a chain of communications that he knows exists, but he hasn't had an opportunity to consider.
Why can't he say in his statement, I know there are some documents, but I haven't had the opportunity of seeing them, and therefore I can't say more than this?
Your Lordship, that would be one approach, but the issue there would be that if there are documents that the defendants are relying on, and the claimant hasn't had an opportunity to consider them, then that would perhaps just give rise to another round of witness statements where the claimant may have to give his evidence, or would have to give his evidence on any documents that are disclosed and that are relevant to the issues in the case.
The documents you're seeking are documents which, on the face of it, your client doesn't have or hasn't been party to?
Our client doesn't have. So, for instance, the financial documents. So,
yeah. So what can he say about them in his witness statement?
Well, Your Lordship, he can certainly refer to them. For instance, he can say that there were business reports, there were monthly reports, there were accountant reports referring to performance, to the fact that LTIC was going to be determined based on EBITDA. I mean, that's the evidence that he can give and will give, but he won't be able to give any nuanced evidence as to what that meant and how it affects his claim, both on liability and quantum. So that's just one example. Furthermore, it's not just the witness statements, it's the expert report as well. And so, Your Lordship, I beg your pardon?
That I understand, but I'm talking about the client's, the individual's witness statements. Seems to me that a witness statement should only deal with stuff that the witness knows about.
And in which case, Your Lordship, what the danger is, and the risk might be, that the claimant, Mr. Kahlon, will give very generalised evidence of the sorts of documents that he knows exist, but without actually drilling down into the detail of how they ought to be interpreted and what they meant. Right. That's the danger, Your Lordship.
Okay.
So, Your Lordship, we ask.
What page are you on now?
Page 469,
the
last paragraph of that letter. We ask for a response to the compromise requests by the 27th of November, 6 p.m. 27th of November, Your Lordship, at page 470, DCO respond, Davidson and Co. And at that point, they say that they've provided 1,753 documents. That's by the 22nd of November. They then, again, very late in the day, informed the claimant that they're preparing a further tranche of documents, which they consider they will provide on the 28th of November. Give an explanation of the delay at paragraph 3. And then paragraph 8, 9, and 10, which is at page 471, deals with the compromise requests. And they simply repeat what they say at paragraph 9. They repeat what they say in their letter of the 8th of November to say that they are willing to engage constructively.
Mm-hmm.
And paragraph 10, our clients have already sought to integrate the compromise requests into our client's responsive production. Accordingly, we expect that both sides will be in a position to address any residual requests that your client may have, and so forth. And, Your Lordship, the problem here is that, again, they give the impression to the claimant that they are engaging with the claimant's reformulated requests, but whereas in their evidence before the court in response to the application, Mr. Swangard's evidence certainly is that they weren't dealing with it and they were only dealing with their own reformulated requests. And Mr. Trotter certainly in his skeleton argument makes the submission that they didn't think it was necessary to deal with these reformulated requests because they were dealing with their own formulated, with their own approach. But more importantly, Your Lordship, what it doesn't do as well, it doesn't give a deadline or a timeline as to when and how disclosure is supposed to take place and when the production is going to be finished.
Yeah.
Page 476.
How much more of the correspondence are you going to go through? Because I'm actually more interested in looking at the particular requests and the objections to them.
Yes, Your Lordship, 3 more letters.
All right. We only
Page
have 2 hours today.
Page 476. I'll whip through these very quickly. Page 476, and maybe just for your own reference, is the 3rd tranche of disclosure that was made. And that was about 1,000 documents. Page 485. Again, asks for a response to the compromise requests, page 4 and 5. Paragraphs 4 and 5, rather, of page 485. Page 486, paragraphs 7, 8, and 9 deal with production relating to Liberty DMCC, which is paragraph 1B of the order, and asks for a response by the 13th of December. Page 487 is the appendix setting out the reasons and the relevance for the Liberty DMCC requests.
Yeah.
Page 488 is I beg your pardon, page 491 is the claimant again raising its concern of the lack of accounting and financial records produced by the defendant and asks for a response by the 13th of December. And Your Lordship, page 493 was really the straw that broke the camel's back in terms of making this application, because 493 was a letter, and this is referred to at C8 of my submissions. It's a letter from GFG Alliance, and paragraph 1 informing the claimant that the defendants are in the process of changing their legal representation, and of course this is the 2nd time in a matter of months. They'll now be advised and represented on the record by a single DIFC-based firm, Altamimi. Notice of change will be filed shortly. And Your Lordship, there has been no notice of change, and Davidson & Co. are in fact still instructed, but this has meant that we've lost about 2 weeks again on production. And just in terms of the RTP.
Sorry, Davidson are presently on the record, are they?
They remain on the record, yes.
But Altamimi aren't on the record?
They haven't appeared at all in these proceedings.
Okay.
So apart from an indication that they will be instructed, they haven't made an appearance. For a short period of time, GFG Alliance and Mr. Swangard were corresponding with the claimant. And then Davidson & Co. have reverted or were never disinstructed, but they remained the legal representatives for the claimant. Okay. And Your Lordship, when I say this was the straw that broke the camel's back, it's because these sort of the claimant's concerns that it was suffering as a result of the production that was being given piecemeal, the vague responses to the claimant's reformulated RTP, the unexplained change of why Altamimi was now going to be instructed at a really critical stage of the proceedings meant that the claimant had no option and was compelled to bring this application and bring it before Your Lordship. And Your Lordship, if there is any criticism, because there has been some criticism by Mr. Swangard about the delay, that's misconceived because of the position taken by the defendant, which is that it was engaging with the production request, when in actual fact, it has never engaged with the claimant's production requests. And that brings me on to Your Lordship, agenda item 3, which is the documents sought and why we seek them and dealing with the defendant's objections to these documents.
Right.
So Your Lordship, I have set out in detail in my submissions, in an annex to my submissions at section E, the requests made.
Right, hold on. These are the submissions I got yesterday, I think.
Yes.
Yeah.
So Your Lordship, my submissions are in two parts. The main submissions at page 691.
No good giving me bundle 691 of what? Are you talking about your skeleton argument?
Yes.
Right. You have to go by internal numbering.
So Your Lordship, my skeleton argument is made up of two parts. The first part is the main submission with the title and the heading Defendant Skeleton Argument.
Yeah.
Page 1 is the introduction and summary.
Defendant. Sorry, you said defendant's skeleton argument. You mean claimant's skeleton argument?
I beg your pardon. Yeah. Yes, I do mean claimants.
Yeah.
And so page 1 sets out the pre-reading. Page 2 is the introduction, setting out the order. And page 5, paragraph 12, provides the structure for the skeleton argument.
Yeah.
And I don't intend to take you through this. No doubt Your Lordship has skimmed it. I'm grateful for that. And I'm grateful for that. And so Your Lordship, in response to your query and your approach of wanting to deal with the request, those are set out at section E. And what I've done is I've taken out section.
Hang on. What page is section E?
So I've taken out section E, and that's an annex to my submission. So this is the second part, the second attachment that you ought to have received.
Where would I find it?
So there's two documents that were served on behalf of the claimant, the main submissions and annex 1.
Right. Okay. Hold on a second. Annex 1. The first section begins claimant's reformulated RTP and rationale for the order sought.
Yes, Your Lordship. Right. To make it easier, so you didn't have to navigate a long document, I've cut out section E, and section E provides the written submissions in relation to all the requests made.
Right.
What the claimant seeks, the relevance and materiality of those requests, and the dealing with the objections. In Your Lordship, I want to take this in very short form, and what I intend to do in these part of my submissions is simply provide the requests that are made, why we make those requests by reference to the pleaded case, and then deal with my learner's friend's objections to those.
Right.
And so, Your Lordship,
what other document do I need? Do I need the draft, Schedule A to the draft order?
Schedule A to the draft order and Annex 1 to DK Singh's first witness statement at page 57.
Right. The trouble is I have two screens. One of them is looking at people in the room. The other is I can manage two documents on it. I can't manage three. So you've got a choice.
Okay. Maybe the approach that I follow is if we look at Annex 1, page 57.
Yeah.
Because that's quite an easy document to navigate. I mean, it makes it certainly easier for me. And I can provide you with the references to my submissions for your written note, but make my oral submissions to you.
Sorry. Tell me what you want me to have open.
So, Your Lordship, the document at page 57, Annex 1.
57 of the bundle?
Yes. I beg your pardon, I should say. 57 of the bundle.
Right. So that's back to 57. Okay. Right. That's Annex 1, page 57. Yeah.
And Your Lordship, just to make things easier, I can refer to the relevant section of my written submissions for your written note.
Well, there's no point in referring me to something you're not going to refer to. I'm going to make a decision at the end of the hearing today. I'm not going to go away and spend 3 days reading. This is, at the moment, I should say that I think the volume of paper taken up and perhaps wasted by 35-paged skeleton arguments and so on seems disproportionate to the issue, which is recovery of documents.
Yes, Your Lordship. It was envisaged that this this application would take place on paper. But notwithstanding that, Your Lordship, I can.
Yeah.
I can, Your Lordship, hopefully short circuit things. I will take you to Annex 1 at page 57 of the bundle, just to give you an idea of what the request is, and then make oral submissions as to why those requests are relevant and material to the issues in the case. When I refer to the issues of the case, I can take you to the pleadings and then give my submissions on what the defendant says on their objections.
Okay.
So, Your Lordship, the first, if you look at Annex 1, page 57, the first request is the compromise request.
Yes.
And that was from the original RTP request number 1. And these are the documents that we seek. Organisational structure documents which show claimant's role within the Liberty Steel Group, the individuals reporting to him and the entities who employed them, and documents showing the position of the first defendant, the second defendant within the corporate structure of the GFG Alliance. And in this respect, Your Lordship, the defendants have only produced 70 documents, and that's in relation to request 1, no documents responsive to request 2. And the defendant's objection.
Yeah, Karen.
The defendant's objections to this request appears to be that they are unnecessary and not relevant to the issues. And we disagree with that. And the reason being is, Your Lordship, as follows. If I can invite Your Lordship to turn up the amended particulars of claim, that's at page 135 of the bundle.
All right. Yeah.
Your Lordship, paragraph 2 of the amended particulars of claim refers to GFG Alliance. It's a company incorporated in the United Kingdom. There seems to be no dispute in relation to this paragraph, in that it's admitted in the defence.
Yeah.
Paragraph 9 at page 136 of the bundle.
Yeah.
States that Liberty DFC and Liberty DMCC form and or operate as part of the Liberty Steel Group. Again, this is something that's admitted by the defendants.
Yes.
Paragraph 13 at page 137.
Yeah.
Initially, it was intended, and Your Lordship, what the pleading there is, from around May 2018, the claimant met with Gupta in Dubai, India, London, Wales to discuss a proposal by Mr Gupta for the claimant to have his lucrative and senior role with ArcelorMittal to take up employment with Liberty Steel Group. And Your Lordship, it was first intended that the claimant would take up employment with Liberty Steel Group, part of GFG Alliance, as we've just seen. And again, this is an admitted position by the defendant in its defence. Paragraph 20.
Mm-hmm.
The relevant part of this paragraph is, and that's at page 139 of the bundle.
I have it, yeah. Yeah.
It's the last sentence.
Yes. I've read it. Yeah.
You've read it. And then the reference to the did not wish to present the claimant's remuneration because other senior managers in the Liberty Steel Group, again part of GFG Alliance. And paragraph 27 refers to Liberty DFC was incorporated on the 18th of February in light of the serious difficulties facing GFG Alliance, Liberty Steel Group and Mr Gupta at the time of documented collapse of Greensill Bank, which had effectively ended Mr Gupta's desire and perceived ability to headquarter Liberty Steel Group in the UK. Mr Gupta's or the DFC is a credible alternative international headquarters with a global reputation, including for regulatory probity and rule of law that he indeed and the claimant believed to match the international reputation of the City of London. And this is why the company was incorporated, the first defendant was incorporated in the DIFC. And so, Your Lordship, the request focuses on 2 categories of documents. The organisational structure, which established the position of the first and second defendants and the entities employing the claimant. And the second category is the corporate structure. And this established the position of the first and defendants within the broader GFG Alliance. And Your Lordship, we've seen GFG Alliance being quite involved in these proceedings. You've seen letters from GFG Alliance, the communication that I just referred you to at page 493. Mr. Swangard, the General Counsel of GFG Alliance, is a witness in these proceedings. Ms. Denise Timmins, HR person, works for GFG Alliance, but in fact was the person who signed off on the 5th of September letter. And therefore we say that the relevance of the documents in relation to both the organisational structure and the corporate structure will shed light on how GFG organises Liberty Steel Group, meaning the two defendants, the continuity of the claimant's employment terms from Liberty Steel Group, or rather the intention of Mr. Kahlon working for Liberty Steel Group, then working for Liberty DMCC, then Liberty DIFC, as we say, and whether or not the 5th of September letter, which was signed off by a representative of GFG, was intended to bind these entities across this organisation. So that's the first part as to why we say it's relevant. The second part is, Your Lordship, the decision-making authority behind the claimant's employment and subsequent termination in May 2022. The defendants argue, Your Lordship, that the documents are irrelevant because GFG Alliance isn't a party to the proceedings, but we say that mischaracterises the case because the claimant's position is that his employment was part of a centralised framework directed by Mr. Gupta and GFG Alliance, under which these two defendants sit, and therefore GFG Alliance and Mr. Gupta influence recruitment of Mr. Kahlon, the employment terms, as well as the termination decisions, and therefore understanding these relationships, the corporate relationship with GFG Alliance, is, we say, essential to assessing the claimant's employment terms and the claimant's employment, the relationship with the defendants, and how that relationship then in turn affects, or rather impacted GFG, or how GFG Alliance impacted the defendants in the relationship with the claimant, how the terms intended to be honoured, and whether in fact they were intended to be honoured. And so, Your Lordship, the defendants claim that the 70 documents are sufficient, but Your Lordship, we say that they only provide partial snapshots, and what they fail to do is address the broader organisational relationships or the decision-making processes behind the claimant's transfer and termination. And Your Lordship, I give a sort of, in my written submissions, I deal with this at paragraphs 10 to 13. Beg your pardon, even before that.
Well, what am I looking at this for? To repeat this same point or what?
Yes, Your Lordship, it's paragraph 4 through to...
Of your skeleton argument?
9.
Of your skeleton argument?
Yes, Annex 1 of the skeleton argument. So section E. When I refer to the skeleton argument, Your Lordship, I'll be referring to section E, Annex 1.
Which I've now forgotten where it is. Can you help me?
It's in the bundle at page 657.
657.
57. Yes.
Give me a second. There's no page number 657. To try again.
Yes, Your Lordship, you may have an older version of the bundle, I'm afraid. These are the attachments that I referred Your Lordship to when I started this part of my submissions as to the request.
Yes, I know it was, but I can't find it presently.
Well, Your Lordship, if I may just give you the references, and it may be that we have a short...
I want the document, please. I remember seeing it. I've forgotten what it looked like now.
Well, Your Lordship, it looks like this. It just says E, claimants reformulated RTP and rationale for the orders sought.
Yeah. So you must have a page number for it.
Yes, Your Lordship, the bundle has gone through multiple updates, and it may be that Your Lordship might be working off an older version.
I downloaded my version last night.
It should be there then, because the bundle that we have currently goes up to pages 8 to 7.
Okay, I've got it now. Sorry, it's under annex to something. Annex to your skeleton argument, yeah?
Yes.
Right, okay.
So, Your Lordship, it deals in there, it's at paragraphs 4.
Yeah.
4 to 9. And it's our submission that the GFG Alliance, which is obvious from the documents, influenced employment matters, and which is why it validates what the claimant is saying in relation to his employment being part of a broader operational framework, which includes GFG Alliance that sits at the top, Liberty Steel Group sits underneath it with the defendants, and Your Lordship, therefore, these documents we say will allow the court to understand how the claimant fits or was intended to fit within the broader organisational framework, specifically because it was intended that he would start his employment with Liberty Steel Group. He was working from England at that point in time. Yeah. In or around May, he came to Dubai and he started on a Dubai Liberty DMCC contract around the 20th of August. But before that, he entered into the 5th of September terms, and therefore, Your Lordship, that's what we say, that these documents are relevant and materials.
All right.
Moving on then, Your Lordship, again, I'm looking at page 57 now.
Yes.
Of the bundle. Again, another annex one. Apologies for all of these annexes. They all appear to be annex one. We'll keep that in mind when it comes to trial. But page 57 is looking at compromise request 2. And Your Lordship, the request description is set out there. Your Lordship perhaps takes a moment to consider that.
Yeah.
And you'll recall when we went through the reformulated RTP, that this incorporates original requests 2, 3, 5, 6, 7, 8, and 11. Yeah. And Your Lordship, this was a streamlined request intending to deal with the reason why the claimant was chosen, the proposed expectations, duties, and objectives, and that goes directly towards the 5th of September letter. But then the second part of that request deals with the 6 agreements that we say have been referred to in the pleadings and form the foundation of the parties' respective positions. And so, Your Lordship, whilst these agreements are there before you, and of course it will be for the court to interpret those agreements on the face of those agreements, notwithstanding that, where there has been a defence of uncertainty being raised, and where there's arguments to say that agreements have been supplemented, modified, or replaced, it will be unclear and it will be unfair to the claimant if the court lacks evidence in terms of how to resolve those uncertainties and ambiguities within these agreements. And Your Lordship, those agreements we've set out in the request, in terms of how they arise out of the proceedings, Your Lordship, do you want me to take you to the particulars of claim as to where they are referred to in there, or?
No, not particularly, but I'm very concerned, Miss Ahmed, about time. We've got 2 hours for this. We've been now an hour and a quarter, and you haven't got beyond the second category of documents that you're seeking to recover. How are we going to deal with this?
Your Lordship, I can short circuit my submissions. At the moment, I was intending to go through the particulars and the pleadings to show how they are relevant to the pleadings. It may be that, Your Lordship, you have dealt with this case before. You've been in the case management conference. You are familiar with the pleadings. You may not need me to go through the central paragraphs of how they arise. And so, Your Lordship, I can short circuit my submissions in that way, or be very quick and take it very quickly.
Well, it's up to you. You've got to persuade me. But I'm just concerned we've spent quite a lot of time this morning on things which I gave an indication at the beginning I wasn't terribly concerned with. Now we're on the meat of the stuff, and we've only got 3/4 of an hour left. And Mr. Trotter has sat very patiently, not saying a thing.
Your Lordship, I'll bear that in mind and I'll go as quickly as I can. In terms of
would it be best on Mr. Trotter? It's up to you, but would it be best on each of these requests, compromise requests or whatever, for us to deal with each in turn, and you speak about the same thing after Miss Armour has spoken?
My Lord, I'm very much in your hands about what would be of most assistance, although I do have a few preliminary remarks I'd like to make. Now, I've heard what your Lordship has said about not wanting to hear about the mudslinging, and I don't want to get into that, but I do just want to contextualise how our document production exercise has occurred to see how these requests fit into what has already been done. I think it's important to understand the nature of the request that your Lordship's being asked to order.
How long would that take, do you think, to explain to me your position on that?
I should be able to do it in 10 minutes.
Ms. Ahmed, I wonder if the best thing would be that Mr. Trotter can deal with his general point, what he's just said first, and then we go through category by category with you explaining why you want these documents, why they're relevant, and Mr. Trotter responding, and I then form a view on each one as we go along.
Your Lordship, I'm very happy with that approach.
You happy with that, Mr. Trotter?
Yes, my Lord, if that would be helpful.
Well, let's do that. Shall we have your 10 minutes first, or 10 minutes or so first, and then we'll have a 5-minute break, and then go through item by item?
Yes, my Lord, I will try to be to the point. I'm sure my Lord will move me on if I'm failing in that regard.
Well, you're entitled to a little bit of leeway, given that the claimant has had a fair bit of leeway.
Thank you, my Lord. I'll try not to abuse that. My Lord, the point that I wish to make is this: that the way the compromise requests have arisen and how they've been treated, and it's important to understand the chronology here. So the claimant's request to produce was served in August. Our objections were served on the 27th of September. Now, in those objections, we accepted some of the original requests, and we proposed certain reformulations of other original requests. And taken together, that's what we've referred to as the original categories. And that reformulation itself involved consolidating certain requests and trying to simplify the quite complex formulations that have been put to us. And can I just give Your Lordship an example of that? If my Lord turns to page 335 of the bundle, and it's the one that my learned friend has already taken you to, request 2.
Yeah.
And so broadly, there is a set of requests originally made in the far left-hand column that concern the negotiation of the terms of the claimant's employment. And as my Lord knows, there are various documents that the parties, one or the other, say govern the relationship from time to time. Now, one can see here that in the middle column, the justification given for the original request 2 is that there were 2 significant negotiations which led to the agreement. And then we have the first 5th of September letter and the transfer to DIFC, Liberty DIFC.
Yeah.
And on the left-hand side, we have quite a complex formulation of the sort of exercise that is required just to find documents about effectively the negotiation of the terms of employment. Yeah. And in an effort to simplify that, in the right-hand column, we've broken it down into 2 requests, A and B. And broadly speaking, A is concerned with the terms of his employment, and B is concerned with the transfer of his employment from Liberty DMCC to Liberty DIFC.
Yeah.
And then one sees if we just go through the document down to 3, for example, the original request on the left-hand side, yes, page 337, request number 3.
Yeah.
We have, again, documents and communications related to the discussions between the claimant and Mr. Gupta concerning the prospective remuneration package. And then there's a series of quite complicated sub-requests. And in the right-hand column, we say, well, that's captured by request 2A. What we're trying to do is to consolidate things into a single, simpler instruction to the people who are reviewing all of these documents. And that carries on through the document. So, for example, we don't need to do all of them, but if we flick down to 339, we have request 5. And again, these are all documents and communications related to the discussions and negotiations of the 1st 5th of September letter. And again, a series of quite complicated sub-requests that goes over the page. And again, we say, well, that's captured by request 2A in the right-hand column. Now, there is also cases in which we've proposed more specific formulations, even though they're perhaps not necessary in terms, given the breadth of 2A. And so if one goes a bit further down to request 6, for example, one sees documents and communications, again, concerning the creation, negotiation, execution of the DMCC standard contract and the DMCC employment cover sheet.
Yeah.
And in the right-hand, and again, a series of 6 quite complicated sub-requests.
Yeah.
And in the far right-hand column, again, although this really comes within 2A as well, because it's all about the terms of his employment, we've proposed a narrower, a more streamlined proposal, which covers the same ground. So communications with the defendants or between the defendants and the claimant regarding the creation, negotiation, execution, or purpose of those 2 documents. And that pattern continues on through these objections, where what we have tried to do is to come up with effectively more workable formulations of, in substance, the same request.
Yeah.
And I should say there are, of course, parts where we have objected and said certain things go beyond what is justified, and there are others where we've just accepted the original request without reformulating it. So that was done on the 27th of September, 2024.
Yeah.
Now, about 6 weeks later, on the 6th of November, is when we received the compromise requests, as they've been called. And that is the document.
What day was that? What day was that?
6th of November, 2024.
Yeah.
I won't show, my lord, the letter again, but it's the document, just so my lord has it in mind, is the one at page 370 of the bundle.
Yeah.
And my lord's already seen that. It's the one with the extra column that's been put on the far right-hand side by the claimants.
Give me 1 second, just so I can remind myself of the...
Yes.
Yeah. Yeah, okay.
So there's a sort of slightly darker shaded blue header in the far right column. Yeah. And
tell me, are the first 3 columns on that the same as the ones you've been showing me?
I think that's the idea. It's, of course, the claimant's document, but I think that's right.
Yeah, okay.
Now, the difficulty is, my lord, that this document comes 9 days before the production deadline and 6 weeks after the objections. So by this stage, the document production exercise is underway. Documents have been harvested, people are reviewing documents, a tranche of 1,000 or so document is produced on the 15th of November. So what these, in the sense in which these compromise requests are unhelpful, is that they perform a similar consolidation exercise, but do so in a slightly different way. And so, for example, if we look at page 371, again, just taking request 2 as an example. So this is the issue about effectively the negotiation of the terms of employment.
Yeah.
We see on the far right-hand side the way the claimant would like to put it. And they now say, and my lord's seen this formulation, it's the decision to approach and hire the claimant, and then 2, 3, 4, 5, 6, 7, 8, the list of contractual documents.
Yeah.
Now, there are minor terms, minor differences of formulation, such as in respect of or relating to the purpose and drafting of or so on.
Yeah.
But it's quite unhelpful to receive a document like this shortly before the first tranche of disclosure is to be given, because the option then is, well, are we required to go back and review everything that we've already done against this new formulation? Answer, no, that would not be sensible. What we did instead, rather than starting the clock back at 0, is say, well, we will endeavour to encourage to have regard to these compromise requests. And that was the correspondence that my lord was taken to. And criticism was levelled at that correspondence. But in my submission, that was completely unwarranted. Mr. Swangard, in his witness statement, explains what we have done to try and make sure that everything relevant and justified is captured by the disclosure exercise that's being conducted. And in particular, there are 2 points that have really been ignored in the reply evidence and skeleton argument again this morning. The first point is, I don't think we need to go to Mr. Swangard's witness statement, because if it's contentious, I'll do so. The first point is that the defendants have not adopted specific narrow date ranges for each of the issues. So the original categories specified a particular date range for the 5th of September letter, a particular date range for the May 2020 contract, and so on.
Yeah.
And then the compromise requests had a set of different date ranges that were slightly narrower in some cases, slightly broader in other cases. But to try and overcome that issue altogether, the exercise that has been done is to adopt a global date range for all of the issues. So the documents have been harvested for the entire relevant period from May 18 to May 22 for all of the issues. That's the first thing. And the second thing is that certain of the original categories and our reformulations only concerned external communications between us and the claimant. And the justification for that was it really only matters when construing a contract, the communications that cross the line. It won't assist.
That's partly true. I mean,
Yes.
Internal stuff can be relevant in testing the probability or otherwise of someone having adopted a certain position at a meeting, for example.
And so to avoid precisely that debate, my lord, what Mr. Swangard explains is that internal communications have been disclosed as well. So we haven't constrained ourselves in that way in the document production exercise. And Mr. Swangard gives 3 examples of those sorts of communications at paragraph 40 of his statement. But of course, all of this has been done at breakneck speed over the Christmas period when no one's really around. So we haven't done a full comprehensive review of our own disclosure in order to show the claimant where the documents he wants are. Now, the effect of that is, and we'll deal with it, this will come up again and again as we go through the various categories, is that most of what the claimant is seeking through these reformulated requests that are just put in a slightly different way are already within the scope of the production exercise. On the other hand, there are, of course, requests that go beyond the scope of the existing exercise, and I've identified the respects in which the requests are broader in our skeleton argument, and I'll do so again when we go through the individual requests. So that's the first overarching point that I wanted to make. There's one more, if my lord, my lord of indulgence will stretch that far.
Yeah.
And it's related, but it's about the claimant's approach to this application. Because, my lord, there are broadly two ways in which one might approach a request for further document production. The first is to look at the objections that have been made in principle and make further requests shortly after the RTPs on the basis that further documents are relevant and proportionate in principle. The second approach is to wait until after document production has been given, actually review the documents, and then make targeted requests to fill the gaps that emerge from that review. Your Lordship may recall that on the last occasion, we advocated for that latter, more practical approach, and that's what we've done on our application. But the difficulty with the claimant's approach is that they haven't really done either of those things. And so the result is we have this slightly confusing and cross-cutting application that has all of the failings of both approaches and really none of the virtues. Because the application is based on the compromise requests that were sent to us before the disclosure was reviewed. That was in November. But of course, the application wasn't made until late December, by which time 3 substantial tranches of documents have been produced. And it seems from Mr. Singh's second witness statement, where he describes 3 times the claimant's review as ongoing, that the claimant has not actually reviewed all of the documents that we have produced. And we identified that specifically in Mr. Swangard's witness statement, and in Mr. Singh's third witness statement, where he responds to that, he doesn't contradict what we say. So we say that this disorganized rush to produce the application has resulted in just taking the compromise requests off the shelf and lobbing them in just before the Christmas period in order to try and gain a procedural advantage. And in my submission, that really leads to the difficulty. That's the reason why we have these cross-cutting requests. And one sees that in the documents that my learned friend took you to this morning, because there's a muddle between the compromise requests and the original categories. So my lord was taken to an annex that showed the documents that were responsive to the compromise requests. But of course, that leaves out of account the documents that are responsive to the broader original requests. And we don't really have any visibility on how those numbers are calculated or how they fit in. But what we can say is that all of the documents that have been produced have been reviewed, and they've been tagged because they were relevant to the original categories, which have either been agreed by us or reformulated by us. So those are the sort of contextual points that I wanted to make, just so we understand how it's come together. And I think that will come up again and again as we go through the individual requests.
So in a sentence or two, what is your conclusion as to the way forward?
Well, my lord, the right approach is, and always was, for the claimants, having waited this long, to actually review the documents that have been produced and to make more targeted requests, not reformulating what's already been done, but for the categories of documents that they say are missing and are genuinely required for them to make their case. Because otherwise it's very unclear what we're being asked to do. I mean, if my lord is asked to reorder a slightly reformulated version of what's already been done, then is it seriously being suggested that we're going to go back and re-review the thousands of documents that have already passed through the hurdles of disclosure and been produced against a slightly different formulation? Or is it suggested that we have to parse the wording of the different requests and work out what is different? Is there going to be a series of satellite disputes about what the differences between them are? And as we go through the requests, some of them are extremely unclear. And we've indicated in our skeleton argument that we're concerned that they are a wedge into something more involved than they appear to be. In the end, my lord has to deal with the application that has been made to him. But my point on all of the requests will be they are either covered by the exercise that has already been done, or they are an irrelevant fishing expedition.
Right. Okay, that's helpful. What we're going to do is take a 5-minute break now. We're not going to finish within the 2-hour slot allocated. Hang on a second. Haley and Alia, one of you there?
Yes, Your Lordship.
Who's that, Alia?
Yes.
Are you okay to sit on a bit after the initial 2-hour slot?
Yes, of course.
Very well. We'll have a 5-minute break now, and then we'll resume. But what I think would be helpful is if you can focus, bring to my attention the precise areas of difficulty between you, having regard to the points you've both made, and see whether we can achieve something. So 5 minutes or thereabouts.
Thank you, my lord.
Thank you.
My lord, I think my learned friend had dealt with requests 1 and 2, so perhaps falls to me to respond on each of those.
Yes, do you want to do that?
I haven't dealt with request 2. I beg your pardon. It was request 1.
Oh, I see.
I was in the process of dealing. I started request 2.
I see.
Well, let's finish off request 1 first. Mr. Trotter, do you want to deal with that?
Thank you, my lord. I'll try to take this one quite quickly so we can move along.
Can I just be clear? Sorry, I keep on having to ask this. It's not your fault. It seems to me there's 3 relevant documents I should be looking at. One is the one you've been referring me to at page 370 onwards.
Yes,
which is the, sorry?
I think we can probably put away that document,
Right.
because all, or at least everything we need in that document is in Annex A to the draft order, which is at page 18.
Right. We haven't been looking at 18.
Ah, I see. It's perhaps a less friendly document, but it does at least have everything in it.
There's one of the Annex 1s is on page 57.
Ah, yes, that is a less helpful document in my submission because it really doesn't contain anything from our side.
Which is the one you wanted to look at?
It's at page 18 of the bundle. It's the
Right.
claimants. It's my learned friend's annex to the draft order, which sets out the request.
We'll just make it bigger. Yeah. Okay.
Yes. So
Right.
sorry.
Annex 1 to draft order. There's too many Annex 1s.
Yes, I think this one might be Annex A actually, or Schedule A, in fact.
Schedule A. Okay. Right. Yeah. Okay.
And so in my learned friend's draft order, she seeks an order in the terms of everything that is in red.
The compromise request. Yeah.
So some of them are the compromise requests, and in some cases, different columns are in red.
Yeah.
And so we're concerned with original request 1 and compromise request 1, which are on page 18.
Yeah.
And compromise request 1 falls into 2 parts.
Yes.
Both of them effectively concern organizational charts or similar.
Yeah.
Request 1.1 I can deal with quite quickly because it is in fact the original reformulated request that we made back in September. So what my lord can see, organizational.
Let me just read it. Yeah, is that the same? Is it exactly the same wording?
It's exactly the same wording. So my lord sees that just 2 columns over in the reasons for the defendant's objection, we say defendants proposed the following alternative formulation.
No, I see that.
Yeah, and so it's the same wording, and so that was proposed in September. Our document production exercise has proceeded, and we've produced 70 responsive documents. So we don't really understand what purpose would be served by an order telling us to do what we've already agreed to do and done.
Well, the only advantage of an order, given it often doesn't matter, but the advantage of an order where things have got contentious is that you can answer it by saying you've complied with it, and then there can be cross-examination if there's a genuine concern that you haven't complied.
Well, my lord, I accept that, but we are already required by virtue of the rules to produce objections to which we haven't requests to which we haven't objected, and we've reformulated the request to which we haven't objected. And my concern about an order is then at the end of this hearing, it will be said, well, there we are. We were successful with a series of orders. We'd like our costs on the indemnity basis, please. And I'm sure my lord will be alert to that. But in my respectful submission, there really is no need for an application for an order to do what we've already done.
Okay.
So that's request 1.1. Then request 1.2. My lord sees just below that. So documents showing the position of D1 and D2 within the corporate structure of the GFG Alliance. So effectively what we're talking about here is all charts that don't refer to the claimant, but just refer to D1 and D2. And my lord, we struggle with the rationale for this. There's a sense in which it will be partly covered anyway, because we've been searching for organisational charts and documents showing the organisational structure with the claimant's role. So some of those will have swept up whatever is available in respect of the entities or entity that employed him. And we haven't excluded documents just because they don't mention the claimant. But approaching it as a matter of principle, we don't follow the justification for this request. So one sees that in the far right-hand column of this table.
Yeah.
And it's a bit wordy, but if one just skips down to the third paragraph, we have the substance of it. And we're told that the court must determine, as a matter of both law and fact, which entity held the relevant legal obligations to the claimant under the 5th of September letter. But my lord, it's common ground that if the 5th of September letter was binding at all, then it was between the claimant and Liberty DMCC. No one says that the 5th of September letter bound any other company other than Liberty DMCC. The only issue is then whether later there was a transfer of the employment from DMCC to DIFC as a result of an oral novation or a contract arising from conduct. So, my lord, this justification doesn't make any sense. And in recognition of that, we've had a series of new justifications in the annex to my learned friend's skeleton argument, and then again in submissions this morning. As I understood it.
Hang on a second. They're wrong one again. Yeah, is this the one that is called Annex 1?
Yes, my lord.
At page, it's attached to the skeleton argument. Is that right?
It's this document doesn't seem to have internal pages. But
it starts off saying Annex 1, then E, claimants reformulated RTP.
That's right, yes.
Yeah.
So
Right.
if one just turns over to the second page of that document,
Yeah.
one sees the series of new justifications that have been put forward for this freestanding search for organisational structure documents. And we could take, there's quite a few of them, so I'll just take them quite quickly. 5.1, the continuity of the claimant's employment terms following his transfer to Liberty DIFC. Well, of course, it's contentious whether there was a transfer, but if there was, then there's no dispute about the continuity of his employment terms. 5.2, the binding nature of the 5th of September letter across those entities. As I said a moment ago, it's not contentious. The 5th of September letter, if binding at all, was binding on Liberty DMCC. 5.3, the decision-making authority behind the claimant's termination. Well, there's no issue about this either. There's no allegation that his termination was somehow not done with the authority of the defendants. The issue was whether it was contractually permitted, and there are separate disclosure issues that will throw up the background to that termination. 6, the reporting structure, role, and employment terms. Well, again, any issue about his own reporting structure will be caught by the existing request which we've agreed, which we've already performed, all charts containing him. And anything relating to his employment terms will be captured by 2A, the general search for the negotiation of those terms. Then we have 7 and 8. And broadly speaking, my learned friend's making a new point here about the influence that GFG Alliance is said to have exerted over Liberty DMCC and Liberty DIFC. Now, we struggle to understand why the influence, if at all, makes a difference. But if it does, then there's no dispute about it on the pleadings. Can I show my lord that?
Mm-hmm.
We'll just step away from this document for a moment and look at the amended particulars of claim at page 136 of the bundle.
Yeah.
My lord have that. So we have paragraph 4, Mr. Gupta has significant control over the GFG Alliance. Paragraph 5, GFG Alliance operates a group of companies known as the Liberty Steel Group.
Yeah.
Paragraph 6, Liberty Group's website records it as having certain divisions and that it's a member of the GFG Alliance.
Yeah.
Paragraph 9, at the bottom of the page, Liberty DIFC and DMCC form and operate as part of the Liberty Steel Group. So that's the pleaded case on how these entities fit together.
Yeah.
And if we look at the defence, page 167,
yeah.
I'm starting with paragraph 6. And these are the paragraphs I showed my lord a moment ago. Paragraph 4 is admitted. Paragraph 5 is admitted.
You say it's all admitted, basically.
It's all admitted. So there's just no issue about this. And if there were, frankly, it's peripheral background. So that's the influence point. And then the last chance saloon is, we're back now in my learned friend's Annex E.
Oh, yeah. Yeah.
Over the page to paragraph 9. It said, court must assess whether the defendants were merely administrative entities. Put aside for the moment what that means. The next sentence, the determination is central to resolving whether the first 5th of September letter and its terms were operationally recognised or disregarded without authority. If GFG's Alliance HR function had the authority to execute the letter, this reinforces its binding nature across the Liberty Steel Group entities, including the defendants. My lord, it's quite imprecise, but it looks quite a lot like an attempt to drive a coach and horses through legal personality and construct a new unpleaded case that the first 5th of September letter is somehow binding on the entire group, or at least on GFG Alliance. That case is not pleaded, perhaps unsurprisingly, and it's certainly not a basis for a roaming inquiry on disclosure.
Yeah. All right.
So that's request 1.
I just want to go back to the Schedule A, the draft
Oh,
order.
yes, my lord, sorry, that's at page 18 of the bundle.
No, it's not the one I wanted, sorry.
Which annex was my lord looking for?
I think I was looking for Annex 1. No, I've got that. Hang
on. Annex 1 to the...
No, it's okay.
Swan Guard, but no, so to the...
To the claimant skeleton.
Oh, I see.
No, it's not the one I'm looking for. Sorry, it's 57 I'm looking for.
57, yes. So, my lord, this is the document that I said a moment ago is fundamentally not very helpful, because what it does is set out what the claimant says are the document production count that are responsive to their reformulated requests. So it's not only have we been totally unable to verify this,
you'll have to excuse me a second. The doorbell's ringing in.
I'm sorry.
Yeah, sorry about that. The problem with working from home.
Not at all, my lord. Yes, I was merely saying that this document, I wouldn't want my lord to think that this document is agreed. It is not. Yeah. It is what the claimants say is the document production count in response to their compromise requests. And we say that at least two things wrong with that. First, it's aiming at the wrong target, because it doesn't estimate, even attempt to estimate, how responsive things are to the original categories. Yeah. And two, we've had no means of verifying these numbers, and in the time available, we just haven't been able to conduct a comprehensive review of our own disclosure to produce this kind of analysis. But in any case, in this instance, on their own count, there are 70 documents already produced in response to request 1. And if indeed it is the case that none have been produced in response to subsection 2, then they're irrelevant for the reasons I've described. But in any case, it's just because they haven't been thrown up by the document review, not because they've been nefariously excluded in some way.
Yeah, okay. I'm just going to ask, is that you finished on this point?
Yes, not obvious.
Yeah. Ms. Armitage, do you want to come back quickly on anything? And as I understand it, yes. The first part of the request, 1.1, is agreed, although there's no need for an order, it said. Why should there be a need for an order when it's agreed and apparently you've had 70 odd documents?
My Lordship, if I may just make very two short points in relation to what my learned friend said about his overarching points. The first one is, well, let me just respond to your question first, Your Lordship, before I go there. In terms of why there ought to be an order, if my learned friend is saying that the review of their documents sweeps up any of these organisational structure documents, then there should be no problem in Your Lordship giving an order, and for the defendants to simply confirm that all documents relevant to the request have been produced, and therefore, as my Lordship has already indicated, this can be a matter for cross-examination. So that would be the first point. The second point is, Your Lordship, that my learned friend keeps saying that even they haven't completed their review, which is slightly troubling for reasons related to the timetable. But putting that to one side, my learned friend also makes a submission that the claimants haven't reviewed the disclosure, and that's, if I've understood the submission correctly, that's not correct. Mr. D. Casing, in his first witness statement, states, and that's at page 44, gives the analysis of the review of the disclosure, identifies the gaps in the disclosure, and Annex 1, page 57, sets out what that detailed review indicated. He also says in his witness statement, Your Lordship, that the review was quite generous, and if there was any relevance whatsoever, then the analysis captured that document, and that's why we say that there are gaps in the production so far, and therefore the 70 documents that my learned friend says sweeps up this request, we say it is not right because these documents haven't been disclosed. And if my learned friend is standing by his submission, then there should be no reluctance to an order being given and a document production statement to reflect and confirm that these searches have been conducted and documents relevant to this request have been produced. And so, Your Lordship, that's the first point. The second point is just to respond to my learned friend's sort of argument about relevance and materiality. Your Lordship, I've taken you to the various references to the amended particulars of claim. And quite frankly, the point is very simple. If one refers to the 5th of September letter, and that's at page 552 of the bundle.
Well, do I need to look at it?
Well, it makes clear, Your Lordship, why we say GFG alliance is quite significant, because what we say is that the GFG alliance, well, first of all, the structure is difficult and complex, and it's quite nebulous to work out who in fact controls the defendants and who the decision makers are within the defendants. And what we say is that the defendants form part of a broader corporate structure whereby GFG alliance sits at the top. And we can see that from the 5th of September letter, whereby GFG Global Head of HR, in fact, signs the letter on behalf of what's said to be the second defendant. And therefore, Your Lordship, what these documents reveal is who has the decision making where these defendants are concerned with regards to the terms of employment, the various contracts that we see in this case, the decision to terminate, and therefore, Your Lordship, that's why we say the organisation chart as to where GFG sits is relevant to understand the broader organisational framework and how how the two defendants sit within that framework for the decision-making processes. Your Lordship, can I perhaps respond to my learned friend's first overarching point?
Very quickly.
Very quickly. So my learned friend said that in his first overarching point that the initial requests were complex. And I think there must be an implicit agreement therein that the reformulated requests weren't complex. And Your Lordship, that was the intention. The intention was to simplify and streamline the request, to take into account what the defendants were saying about the original request and try and engage in a balancing exercise. Now, the problem that the claimants faced was that the impression given in the letters was not that Mr. Swangard or the defendants were endeavouring to comply, but that they were in fact engaging, but when they were not. And what seems to have happened in the approach that my learned friend has provided today, and the first time that we heard and read in Mr. Swangard's witness statement, is that the defendants appear to have completely disregarded what the claimant's specific requests are, instead focusing on their own objections and alternative formulations. And what we say the problem with that is that it narrows the disclosure on their terms, it bypasses the targeted request that the claimant makes, and therefore, coming back to your first question and your point that was made, really, Your Lordship, is that if an order is made in the terms sought, and if my learned friend or the defendants don't have those documents, it will be quite a simple exercise to simply say, we don't have these documents, and therefore, Your Lordship, that can be taken forward at trial, and clearly findings will depend on what production has been given and what hasn't been given, especially in a case where there's quite a large dispute of fact in relation to the key agreement, the 5th of September agreement, where the defendant's case is it's non-binding, it's unenforceable, it's uncertain about the key provisions. And so, Your Lordship, we say that Your Lordship perhaps can circumvent all of this, provide the order. And if my learned friend's position is, well, look, we can't go back and re-review production, and at the same time says that we haven't had an opportunity to do so, we say, Your Lordship, well, that's their problem, because if they failed to comply with their disclosure obligations, failed to complete searches properly, then the claimant ought not to be prejudiced by their failure to comply with their search, with the search obligations and disclosure obligations. And so, Your Lordship, that's what my position and claimant's position is in relation to the points made by my learned friend.
Do you yes, Mr. Trotter, I take your point about about the relevance of this of 1.2, in a sense, you say there's no issue because you showed me the passages in the pleadings which are admitted and so on. But is there a separate concern about the width? Because there's no date attached to 1.2, no time period.
Well, quite.
If 1.2 was limited to date-wise to the period between the first contract, the first letter, I always forget the date of it.
15th of September
letter.
Yes.
First September letter and termination of the relationship. Would that then be a very onerous task?
Well, my lord, the difficulty is we've already conducted an exercise of reviewing for organisational documents. We've found 70 documents and disclosed them.
I thought the 70 related to the first 1.1.
Well, as I said, we haven't excluded documents just because they don't refer to the claimant.
Yeah.
Now, if an order of that kind is made, the practical effect is that we need to go back and search through documents again with this new reformulated request in mind. Now, in order to justify that sort of exercise, my submission, then there needs to be some prize at the end. And based on the many and varied relevance justifications that have been put forward, there just isn't one. And a series of document charts, if they exist, that refer to D1 and D2 but don't refer to the claimant, therefore don't fall in request 1 but do fall in request 2, are just not going to be helpful. And so there's quite a lot to do in this case in order to get it to trial in March.
I take your point. Well, I think I'm going to give my decision on each one as we go along, and then no doubt, Alia, are you there?
Yes, Your Lordship.
Yeah, if you can make a note as we go along of my decision on these various points.
Of course.
I'm sure the parties will themselves record. It seems to me that the 70 documents given and the lack of opposition to 1.1 should provide some assurance that there is sufficient disclosure. And it seems to me that if there is a particular lack, having assessed what has been given already, then the specific application can be made, first of all, by correspondence, but secondly, an application to the court if necessary, justifying it on the basis of the inadequacy of what's been given. And I am conscious of the fact, which I think is a sound point that Mr. Trotter makes, that we don't want to be making orders that require the redoing of everything that's been done already. You should be looking for what's missing rather than generally a comprehensive restatement in a slightly different way of what's already been asked for and looked for. So I'm minded not to make an order for the moment on this one, but reserving the right, and this will apply generally throughout, reserving the right of the claimant to make further application if specific gaps of relevant material are identified. So I'm not going to refuse it. I'll simply, what's the right approach? Is it to refuse it, or to simply make no order for the moment on request 1?
My lord, in my submission, the right approach in principle is to dismiss the application that's been made on this and grant liberty to apply to make any further targeted application that may be necessary. I mean, that liberty is not really required because the claimant always has that liberty. If on review it turns out that there's some particular part of the jigsaw that's missing, they can either write to us and ask the question, and it may be that it can just be agreed, or if they want some document because there's some contentious point, then that's a very specific issue can be explored. But at the moment, if my lord's not making an order on the request that's been made, then the appropriate approach in principle is to dismiss it in my submission.
My lord, my submission would be to just simply state no order as yet, but reserve the position, especially because we get to this in January when the first requests were first filed on the 6th of November, Your Lordship. So we've lost quite a lot of time, and we have assessed the request. And it may be that we could potentially narrow the request, but
I think, Ms. Ahmed, I'm going to cut you short. I take your point, but it seems to me that the right approach at this stage, if you've identified particular things that are missing, or things that have, if you can't identify a document that's missing, identify a category of document that simply doesn't appear where it should be, it should appear in answer to the request, then you make that focused request. And I think in the meantime, I should dismiss item 1, claimant request 1, with liberty to apply.
Thank you,
Yes.
my lord.
2.
I'm
I think
grateful, Your Lordship.
Yes.
My Lordship, then if we turn to request number 2, that's
What
at
document? Page what?
page 19 of Schedule A, which is 19 of the application bundle.
Oh, God. 19.
And Your Lordship, you'll recall that these requests incorporated a number of requests from the original RTP.
Yes.
And it won't surprise you to say that we disagree with my learned friend, and when he says that the initial requests were complex. But in any event, I don't think that's relevant for today. The point is, Your Lordship, if one reviews the requests, we say that the requests are narrow in scope, they're detailed, and they have date ranges, and therefore, Your Lordship, we say that there's nothing particularly complex or difficult about these requests that are being made. They form 2 parts. The first part is the decision to employ the claimant, and that's relevant to understand the intention of the parties behind employing the claimant, and the 5th of September letter, the first 5th of September letter, particularly where, Your Lordship, the defendant says that parts of it are unenforceable and uncertain and ambiguous, and therefore it would come to the court to determine what the parties' intentions were. The second part, it relates to the various agreements that are central to the case, some more key than others, clearly. For instance, the letter at B3, B4, so in terms of the claimant, B3 obviously, but B4, B5, B6, B7, those are all documents relied on by the defendant, and the claimant says that those aren't binding. And document 8 is a confidential side agreement that the defendants referred to in their defence. And before I take you to the pleadings, the reason and the rationale for these requests are that we say, and particularly in relation to internal emails, because what hasn't been disclosed, and Mr. D.K. Singh provides his analysis of what has and has not been disclosed, but there are gaps in the material in relation to internal emails that we say must exist with regards to the terms of these agreements. So that's missing. The other documents that are missing, Your Lordship, are the various drafts that would have been produced, crafted, and decided upon by the defendants. And so these are the defendants' documents, and therefore we say that these would be naturally in the defendant's possession, custody and control. And therefore, Your Lordship, we say that these are key for the court to understand and determine what was the decision-making process, what were the negotiations behind each agreement, what was intended behind the agreements, and of course, evaluate what the parties understood, or again, the intentions, using the correspondence, using the conduct, and any other extrinsic evidence to determine whether or not a binding contract arose with regards to these agreements. And we say that's why these agreements are relevant. With regards to where these agreements are referred to within the pleadings, Your Lordship, can I invite you to turn up the amended particulars of claim? That's paragraph 16 at page 138. And what the claimant says is that after the agreement had been reached with Mr. Gupta, and it's denied in the defence at paragraph 16.1, page 169, and I can take you to that page after we deal with the amended particulars of claim, but it's denied by the defendant that Mr. Gupta reached an agreement with regards to the core terms. And then it goes on to say that the claimant duly entered into correspondence, and Ms. Timms, who was the Chief Human Resources Officer for GFG Alliance, reduced the agreed terms to writing. Then the 5th of September letter is referred to paragraph 17, 18, 19, on or about the 29th of August, that's page 139, the claimant discussed the offer with Ms. Timms at around noon UK time. Following this discussion, Ms. Timms emailed the claimant on 29th of August. And that's one example where we said that there would have been some sort of internal trail, internal correspondence, whereby Ms. Timms was reporting back to Mr. Gupta the nature of her conversations. And therefore, there ought to be some documents with regards to what was going on in the background when Mr. Kahlon and Ms. Timms were dealing with each other with respect to the 5th of September letter.
Yeah.
Then paragraph 20 again. Second sentence, after further discussions with Ms. Timms, she spoke to Mr. Gupta and came up with a final offer. And therefore, there's a direct pleading to say that the claimant was aware that Ms. Timms has spoken to Mr. Gupta, yet there's no documents with regards to any of those discussions that may have happened with Mr. Gupta. Then we turn to paragraph 21, which is the actual letter itself. And so, Your Lordship, with regards to the 5th of September letter, if one turns at the defence, there are a number of disputes in relation to these documents. So I took you to paragraph 16. The relevant page in the defence, or paragraph, is 16.2.
Mm-hmm. What page is that?
Page 169. In 16.2, it's admitted that Ms. Timms engaged in correspondence with the claimant with a view to further negotiating and agreeing contractual terms in respect of the claimant's employment as pleaded to further below. But the claimant's position is that she would not have done that in isolation. There would have been some sort of interaction with Mr. Gupta, and therefore, Your Lordship, we are requesting records of any interaction, be that memos, minutes of meetings, emails, any communication and documents that go back to or refer to and are relevant to the creation, rather the first 5th of September letter. And not only that, Your Lordship, any other versions of the first 5th of September letter. As I've said, Your Lordship, these are documents that the defendant produced, and therefore it is realistic to assume that there must be other versions of this document. And therefore, Your Lordship, we say that those documents are also relevant. With regards to paragraph 16, again, in the defence, and it's paragraph 17 of the defence, it's at page 169.
Yeah.
Paragraph 17 is admitted to say that it is denied that the offer set out in Ms. Timms' email was purported, nor is it understood that this expression is alleged to mean in the context pleaded. So that deals with paragraph 17. Paragraph 19, where the claimant discussed the offer with Ms. Timms, the defence records at 19.2, which is at page 170,
Yeah.
admits the second sentence of paragraph 19, but says that it wasn't sufficiently certain, and denies that the email was part of the process to formalise the agreement that had already been reached. And therefore, again, the point is that one would expect there to be documents and records and communication with regards to the process to formalise the agreement. Yeah. And paragraph 21 of the particulars of claim is the first 5th of September letter itself. the defence that deals with that is at page 170, paragraph 21. And that just simply, well, it doesn't simply, but there's a whole kind of section denying the enforceability, binding nature of that first 5th of September letter.
And so what has been given so far in response to
we
this
say
request?
that the defendants haven't provided any internal emails that we anticipate to exist. They haven't provided any.
Have they disputed the relevance?
Well, Your Lordship, what they say is, as I understand from my learned friend submissions, and I think it's paragraph 16 to 22, is that they say that it's unnecessary, and that they were, as I understood the submission, they were dealing with their own reformulated request. But we say that that's not sufficient because that's narrowing really the scope of the request that's being made, and it applies to all of these documents in short, which is internal emails, documentation, documents, records of meetings. They haven't responded to that. Those are necessary. And the defendant's reformulation, we say, is narrowing of the request. And so what they say, and I'm just looking at my learned friend's skeleton argument, is that they have conducted searches, and I'll bring it up so I'm not misrepresenting the position. Paragraph 9.
What paragraph?
It's paragraph 19 of the defendant's skeleton argument.
Yeah.
Page 697. And that seems to be the nub of the objection. Well, first at paragraph 18, they say they've already harvested and searched for documents. But again, Your Lordship, they've had this since the 6th of November. In circumstances where they say they're engaging with it, we say that it's not sufficient to say, well, we were dealing with our own requests. But paragraph 19 seems to be the nub of the objection. And they say that the defendants have searched for and produced documents relating to the terms of his proposed employment, including the negotiation and internal consideration. The slightly different wording used in claimant's new request makes no material difference. But we say, pardon, I beg your pardon.
What's wrong with that? If they have searched for documents, quotes relating to the terms of the proposed employment, wouldn't that cover everything you've asked for?
Well, Your Lordship, what it doesn't cover are the various versions of the various agreements that we anticipate exist. That's just limiting the risk.
Why not? If it's documents relating to the terms of proposed employment, that would surely cover different versions, different drafts, different discussions about it.
Well, Your Lordship, the terms of the proposed employment gives a rather vague characterisation to these agreements. I mean, there are 6 agreements that have been pleaded to. Which agreement is it referring to of the proposed employment? The proposed employment was the proposal made back, and in the pleadings you saw the proposal was for the claimant to be employed by Liberty Steel Group. But and so, Your Lordship, it's not clear to us whether or not, well, first of all, what search terms have been used precisely, what date ranges have been used. Relate to is quite nebulous and vague. And so, Your Lordship, if the search terms relate to specifically the agreements, then one could see the point being made, but they don't. Relating to terms of employment, we say, is quite vague. We also say it's an artificial narrowing of the scope when the scope's quite clear. There are, as I've said, various terms here.
How does it narrow it?
Well, Your Lordship, because there are more or less 6, well, there's 6 agreements here. So what does proposed employment even refer to? Well, which agreement does it refer to? Which time period does it refer to? Because these agreements deal with different time periods. And we have specifically sought internal documents and communication. It's not clear which custodians have been searched. No drafts of any of the agreements have been disclosed. Whereas it's quite.
Hang on. They said they've harvested and searched documents for each of the 7 custodians named in your request. So you can't just say it's not clear which ones they've searched. They've trawled.
Well, Your Lordship, I
mean, isn't this a problem that you haven't seen what they've given you yet?
Well, Your Lordship, we have. We have.
Yeah.
I can turn you to Mr. D.K. Singh's witness statement, and my learned friend keeps saying this, but and it's wrong. If I can take you to page 30 of Mr. D.K.'s witness statement.
No, what a paragraph number?
Yes, I'll take you to that. It's the analysis, I think, at section C, which starts at page 44.
Can you avoid page numbers of a bundle which I'm not using?
I'm so sorry, Your Lordship. I beg your pardon.
It has paragraph numbers.
It has paragraph numbers. Paragraph 54, internal page 15. The claimant's review of the defendant's specific production confirmed the validity of concerns raised throughout these proceedings regarding the adequacy and responsiveness of the defendant's disclosure. Despite the production of 2754 documents, a significant majority were either irrelevant or of limited utility. It's apparent the defendants have failed to meaningfully engage with the claimant's reformulated RTPs. Turning over the page at page 56, or rather 57, of these, paragraph 57, of these 2,754 documents, only 395 documents, which is 14.34%, were determined to be responsive to one or more of the claimant's reformulated RTPs.
I must be looking at the wrong document.
I beg your pardon.
I'm looking at Sing 3. Is that right?
I think no, it's Sing 2. Sing 3 is a reply statement. Sing 2.
Sing 2 is in the bundle then. What page is that of the bundle?
Page 44.
44. Okay, yeah, sorry.
Paragraph 54.
Yeah.
That's under the title Analysis of the Defendant's Specific Production. Halfway through that paragraph, despite the production of 2,754 documents, a significant majority were either irrelevant or of limited utility. If we turn over the page, paragraph 57, of these 2,754, only 395 documents, 14.34%, were determined to be responsive to one or more of the claimant's reformulated RTPs. A detailed table analysing the responsiveness of the documents to each request is set out in Annex A, which is the document at page 57. I'm told by my review team that they applied a generous standard when assessing responsiveness, ensuring that any document with even limited relevance was included as responsive. Despite this wide net, the relevance of many marked documents to the substantive issues in dispute was marginal at best. What is particularly striking is the minimal production of documents in response to requests that should have been straightforward. For instance, original request 14, which was expressly agreed between the parties, yielded only 4 documents. Where the claimant accepted the defendant's reformulation of original request 15, which also covered original request 16, the reformulator request 15 yielded only 45. The overwhelming majority, 85.65% of the specific production, consisted of documents that were entirely non-responsive to the issues in dispute. My review team reported significant volumes of irrelevant material, such as diary entries without meeting, context, and travel engagement records, which hold no relevance to the matters at hand.
So you're complaining they've given you too much?
They've given us too much irrelevant material. I think the point is they dumped about 3,000 documents. When the defendants were asked to clarify which of those documents were responsive to any of the claimant's request, they said, it's not our problem, you do the work. And then, Your Lordship, the documents that were reviewed, only 14.4% were relevant.
Okay. Right. Shall I hear what Mr. Trotter has to say? Mr. Trotter.
Thank you, my lord. Can I just deal with that last point first? First of all, the status of the review. I didn't say that the claimants have not reviewed any documents. What I said is that Mr. Singh has described the review process as ongoing. I wasn't going to take Your Lordship to the witness statement, but I ought to do that. So if we just turn to page 39 of the bundle.
Yeah.
So we see, first of all, there at paragraph 33, in the course of KBH's ongoing review of specific production. Yeah. And then over the page at page 41.
Omissions were identified. I think that's saying, isn't it, that during the 3 tranches of disclosure, there was an ongoing review and omissions were identified.
Over the page at paragraph 41, page 41, paragraphs 43, again, we have in the course of KBH's ongoing review, and my learned friend will no doubt point out further omissions are said to have been identified.
Which led to the letter of the 9th of December.
I'm sorry, my lord, but I haven't interrupted my learned friend in her submissions.
If you allow Mr. Trotter to make submissions.
Of course, but Mr. Trotter seems to be misinterpreting what's being said and giving selective evidence. I appreciate that, Your Lordship, of course.
I understand. The point that's being made is that Mr. Singh is referring constantly to KBH's ongoing review, which suggests it's ongoing. That's right,
and then it goes further, because we've then specifically pointed this out in our responsive statement. So if one turns to page 67 of the bundle.
Yeah.
We've said, if one looks at paragraph 18, we haven't beat around the bush here. We've said exactly what I've said today. In the middle of that paragraph, claimants delayed making its application until after significant costs had been expended, and yet launched it immediately before Christmas without actually completing its review of the documents produced to date or tailoring it to what is genuinely required. Now, there was a reply statement filed in response to this, and this paragraph, it's not like this paragraph was ignored because it was specifically dealt with. So if one looks at page 108 of the bundle, paragraph 17.
Hang on.
Sorry.
This is what, Sing 3?
This is Sing 3. So this is the reply evidence filed in response to Mr. Swangard's. So paragraph 17 starts off addressing the commentary in respect of alleged deficiencies. And then one gets into paragraph 18, there's various points that are taken. And at paragraph 18.3, there's a reference to paragraph 18 of Swangard 1. That's the paragraph that we were looking at just a moment ago, where we made the specific point. And there are various points made here in this paragraph, but nowhere is it said, well, Mr. Swangard is mistaken. My team has reviewed every document that's been produced. We've conducted a comprehensive review. That's just not in evidence. Now, my learned friend says from the bar table now, everything has been reviewed. Maybe that's the case, I just don't know, but it's not in evidence. And this is the basis on which we've approached the application. And it's apparent that not everything has been reviewed. For example, because just yesterday, we received a letter about a document that had been produced in June last year that apparently hadn't been registered by the other side at all of a sudden clamouring for native versions and so on. And that was provoked because we put it in the bundle for this hearing. Now, I'm not going to go into all of that detail, but that is the basis on which I made the submission. In a sense, none of that really matters, but I just need to correct the position because of the way it's been addressed. Now, what does matter is this particular request, request 2.
We're at page 18, are we, of the bundle?
Yes, if we just go back to page 19 now, I think.
19, yeah.
Yes. And in a sense, we've traversed this ground a little bit already, because request 2 was the example I gave in opening of the request relating generally to the negotiation of the terms of employment. And I explained how we had made our own attempt to consolidate it into a more simple, straightforward request. And then later, on the 6th of November, we received the claimant's own separate consolidated request. Now, there's various suggestions in submissions that it's hoped to sound clear what the custodians are or what the date ranges are and so on. Well, this has also been addressed by Mr. Swangard in evidence. So can I take my lord to that? We're back in Mr. Swangard's statement at page 75.
What paragraph is it?
paragraph 36. In any event, the defendants have already included each of those key individuals.
Sorry.
I'm so sorry. Page.
Okay.
Yeah.
Yeah, I've got.
My lord says that in paragraph 35, there's a list of people. Those are the people that the claimant wants included. And Mr. Swangard confirms in paragraph 36 that the existing exercise has already harvested documents from those people.
Yeah.
And my learned friend will say, well, why wasn't that set out in the request? And the answer is, well, that's not the purposes of the request. The request set out what the topic is, and then you embark on your disclosure exercise, you investigate who the relevant people are who are going to hold these documents, and you harvest the documents and you review them. And then all of that detail will be set out in the document production statement in due course. But there we are. There's the evidence that the custodians have been captured. As to the date ranges, we see that on page 78.
So paragraph what?
Paragraph 48.
Sorry, I've got this as a separate document. So.
Oh, I'm so sorry, my lord. It's internal page 16, paragraph 48.
Okay. Yeah.
And here, Mr. Swangard's explaining, in the context of request 2, in any event, in order to ensure all relevant documents have been captured, we haven't applied specific date ranges request by request. Instead, we've had a global date range that runs all the way through to May 2022. So that puts that to bed. And then the last objection was that there were no... I'm sorry, my lord.
Sorry, carry on.
Was that there was no internal communications. It was said that all we'd done was produced communications that crossed the line.
Yeah.
And I touched on this earlier, but just to show my lord the evidence, it's internal page 14, paragraph 40. And it says, we've disclosed internal communications, i.e. communications to which the claimant was not a party in the relevant date range that concern the terms of the claimant's proposed employment, which were located in the course of the review. And then there's some examples given in 40.1, 40.2, and 40.3. Now, I don't say that that's an exhaustive list. We haven't, in the 7 days allowed over Christmas, re-reviewed our own disclosure entirely. And there was some criticism by my learned friend that we haven't given our disclosure with a set of information explaining which document relates to which request. But my lord, the claimant hasn't done that either. And it's not the usual practice. So I'm not sure what the forensic purpose of that submission was. But the upshot of this is that the exercise that we have conducted, that Mr. Swangard has explained, is in fact broader than what my learned friend is requesting. Because if we just go back now to the annex in page 19.
Yeah.
One sees in the list, 2, 3, 4, 5, and so on, there's quite narrow date ranges that apply to each of them.
Yeah.
And as I've explained, we haven't adopted those narrow date ranges. What we've done is selected the whole relevant period and reviewed documents that are relevant to the terms of employment.
Yeah.
Now, there is one respect, though, and I said that I would identify the respects in which the claimant's requests go further than what we have done. There is one respect in which this request does go further, and that is sub-request 1 in red.
Yeah.
In this list. And so
just
yes, my lord. So just to orientate, my lord, that 2, 3, 4, and 5, and so on, they're all the contractual documents. They're all swept up. I mean, there's some suggestion that documents relating to employment terms was somehow meant to confine the request in some nefarious way. That's certainly not the case. It's deliberately broad wording. But then request 1 is a new request which extends the real substantive effect of this is to extend the date range backwards. So all of the requests made by both parties in August and September started from May 2018 onwards, because that's when the negotiations began. For the first time in this compromise request, it's extended 8 months back further into the past. And so one sees in brackets below 1, between the 1st of September 2017 to the 6th of September 2018. Now, the justification that's given for that is in the far right-hand column. I'm sorry, my lord, just let me orientate myself. Perhaps the best place, in fact, to see this, the most up-to-date explanation at least, is in my learned friend's skeleton argument. So perhaps we should look at that. It's in the annex, which is the extracted section E.
Yeah.
Which you saw previously.
Yep. Page, paragraph.
Paragraph 21.
Yeah.
And so just if we just go back actually to paragraph 14, to see again how this fits together. So the claimant has broken this up into category A and category B.
Yes.
And in fact, it's my claimant, it's my learned friend that uses the words under B, the terms of the claimant's proposed employment. And then under that, she lists the 6 instruments.
Yeah.
So that's the part we say is already dealt with. Section A.
That's what you say has already been dealt with, as covered by your skeleton, the paragraphs 18 and 19.
Yes, my lord.
Yeah.
And in fact, I'm reminded that not only is there the general sweep for anything that has anything to do with the terms of employment, but for good measure, we have a number of specific issues which we offered, which relate to specific contractual documents. Perhaps I'll also just show my lord that before moving on to what isn't covered.
Yeah,
I don't think it won't take very long, but we started on this actually when I was doing my introduction. But if we go to page 340
of the bundle.
So we have, and in a sense, I reiterate, my lord, in a sense, none of these are necessary because they're all swept up by the general review for the terms of employment. But just to put it beyond any doubt, number 6, one sees in the far right-hand column.
Yeah.
This concerns the DMCC standard contract. And it's documents relating to the negotiation, execution, or purpose. And then B, specifically drafts of the DMCC standard contract. There was a point taken about that. So there has been a search for those. And if we go over to page 342.
Yeah.
Now we're talking about side agreements. And this specifically arises because if one looks in the middle of the page at the claimant's reasons, claimant says that there was a conversation with Ms. Timms where it was said that the LTIP was intentionally excluded because there was a practice of separate confidential agreements. She intended there to be a separate confidential agreement. So that's why this point arises. And the alternative formulation that we've proposed, therefore, is specifically documents related to that conversation, and B, documents relating to the proposed use of a confidential side agreement. So there's a specific issue in relation to that as well. And then if we go over the page, 8, again, we can just look at the right-hand column. Communications within the defendants. So again, expressly referring to internal communications or between the defendants and the claimant regarding the creation, revision and distribution of the May 2020 contract or the 2nd, 5th of September letter or the rejection of that. And capital B, drafts of that contract or the 2nd September letter. So that's specifically dealt with by its own issue as well. So not only is it swept up by the general review, but for good measure and for the avoidance of doubt, there has since September been these specific issues in the defendant's own reformulations. And that is the basis on which the defendant's document production search has proceeded. So there really is just no doubt about that set of document review. So really this dispute is, or at least should be, all about whether it's appropriate to extend the date range back by 8 months to September 2017. And there we do take a relevance point. So before that diversion, I was in my learned friend's annex to the skeleton argument at paragraph 21.
Yep. No, sorry, paragraph 21. Yep.
Yes, there's a heading that says category A1, why the claimant was chosen.
Yeah. Got it.
And we see this is the justification given. The claimant's decision to join the defendants was based on representations made by Mr. Gupta. Those representations can inform whether the terms later reflected in the letter were integral to the agreement. So what we're talking about is representations made by Mr. Gupta to the claimant. But my lord, if we look at the amended particulars of claim, page 137 of the bundle,
yeah,
paragraph 13, we see this is the claimant's case. So that from around May 2018, the claimant met with Mr. Gupta in Dubai to discuss a proposal.
So your point is nothing going back to September 17.
That's right. There's no, the date 2017 does not appear in the claimant's pleading. All of the requests made by both sides dated from May 2018 onwards for the first couple of months of this, well, at least from the objections given in, well, from the request given in August through the defendant's objections in September, all the way down to the 6th of November, 9 days before the deadline, no one was suggesting the documents should be harvested before May 2018. And one sees why that is. Because it just wouldn't serve any purpose to go back and excavate to a time when the claimant wasn't even involved. There were no negotiations. Now, we've made some inquiries in the very limited time that's been available about what this exercise would involve. I have to emphasize this, we've made these inquiries in a very short period of time, at a time when personnel have been seriously unavailable. So it hasn't been easy to obtain the necessary information. But my instructions are, and this is in my skeleton argument, so perhaps I ought to show my lord that. It's at paragraph 22.
Yeah.
Now, I need to be clear, this isn't in evidence. The reason it's not in evidence was because the information just wasn't available by New Year's Eve. But on instructions,
yeah,
that we've previously explained in evidence on the last occasion that the emails are split between two different systems. So they're split between Microsoft Purview and, for emails prior to January 2021, an archiving system called Barracuda Mail Archiver. Now, a preliminary search that's been conducted of that shows that for the 7 custodians, there are 45,000 emails for the relevant period. Now, it hasn't been possible to work out how many emails there are between the 42 different sets of custodians, so 7 custodians all emailing each other, because the functionality limitations on the archiver mean that it would take 2 weeks just to conduct that exercise. It's not a terribly friendly archiving tool. But there would need to then be a review and filtering of those documents for relevance and privilege before they could be produced. And on any view, for an extra period of 8 months for 7 different custodians, this is going to be a substantial task. We can't yet say exactly how long it would take, but what we can say is, based on the pleadings, it doesn't look like it's going to produce anything of value. And so the prize on the information before your lordship is just not worth the effort. The basic point is it's not relevant. It's a fishing expedition. And again, I repeat the point, there's an awful lot to do in this case, and neither my learned friend nor I need the distractions.
Is that it?
Thank you, my lord.
Ms. Ahmed, what I'm interested in particularly is that last point. There's no pleading going back before May 2018, I think it is. In other words, what is the relevance of the documents you seek under the first part of Compromise Request 2, which is the period between September 2017 and September 2018?
My lordship, it's not entirely clear to me, so I may have to take instructions on that. But your lordship, what would be relevant on the pleadings is that if the date range was from May 2018. But like I said, I will take instructions on why the 1st of September 2017 is the date range.
This seems to be the sticking point, because everything else has been covered according to the defendants.
Well, my lordship, can I come back on those points that my learned friend made, and particularly, my lordship, the question that you asked me about why is it said that the relate to terms search term is too narrow? And my lordship, just dealing with that point, and maybe I take it slightly differently. Under the rules, and it's 28.20, the defendants are required to produce a document production statement, and that's one of the reliefs that we've sought in our order. And the point of that is, your lordship, that what that says is that it provides, or it has to set out the search for documents undertaken, reasonable search, those documents in their possession, custody and control, and I'm just reading from RDC 28.20, provide to the other parties information about his document retention policy, and state to the best of his knowledge that he has produced copies of all documents in his possession, custody and control which have been requested and to which no objection is raised. And that's obviously with those documents relating to any objections that have been made. But what my learned friend seems to be saying in his submission is that to some extent they have complied and they have undertaken these searches, but only not in the way that we have wanted, or the terms that we have wanted, but there has been some searches made. And so, my lordship, the first point there is, if that's right, then they ought to be, well, that ought to be set out in a disclosure document production statement, which we've asked for and which hopefully will be forthcoming now. But turning then to what was wrong with what we say is a very narrow construction of the relate to terms. And we say that it is narrow because what it does, it risks missing critical documents. And for instance, we say that it may be that the search hasn't picked up what synonyms could be for term. For instance, was the search expanded to include conditions, provisions, obligations, responsibility, agreements? We don't know whether or not that search was undertaken. We don't know whether or not there was a specific reference to the claimant's employment. Terms seems to be quite restrictive. It could be expanded to employment terms, contract terms.
It says the skeleton says relating to the terms for his proposed employment.
But your lordship, terms is just it's one way of describing these provisions within the contract. Well, terms, your lordship, the point is that the employment terms, some of these contracts don't cover employment terms, or the terms under which the claimant was employed. And therefore it may be that, or rather we would say, there are other synonyms that could have been applied, and we don't know whether or not they were applied, that could have expanded the net and therefore could have expanded the search. And we say that just to say relate to employment terms is very restrictive. I mean, one example, as I said,
including their negotiation and internal consideration.
Well, Your Lordship, in terms of the platform, the search platforms, one would have to give very specific search criteria to the platform in order to bring up documents relevant to it. And Your Lordship, it's not clear to the claimant, and it's not clear to me, whether or not that's just a generalised term or the precise search terms that were applied to the documents that have been searched. That's our concern with just restricting it to relate to.
Well,
or relating to. I mean, in paragraph 19, it's in quotation relating to. The terms of his proposed employment doesn't appear to be the exact specific search term that was applied to the searchers or put into the platform. It's just, Your Lordship, it's just simply not clear. But coming back to my first point, if my learned friend is saying that these searches have been conducted, then what we would argue is that the production statement, the document production statement that's required and is an obligation to be provided under 2820 should be provided, setting all of this out. And so it's clear to us.
Well, no doubt it will be.
And in which case, Your Lordship, then it's a question of timing.
If it's a requirement, I haven't actually checked this rule. If it's a requirement in every case that be done, then it'll be done, I expect.
Yes,
rule 28 to say.
2820, within the time ordered by the court, the party to whom the request to produce is addressed shall carry out a reasonable search for documents as to which no objections have been made. And so if the point that my learned friend is advancing, that the documents that they have carried out an extensive search of over 6,000 odd documents, and that search has swept up many of the claimants' requests that are being made, then it's in effect no objection. And if that's the position that my learned friend is taking, then that ought to be set out in a document production statement, and that's at 2820. And the problem that the claimant has had is that no document production statement has been forthcoming, and therefore it's been impossible to assess the adequacy of what my learned friend is saying, which and the defendants have said for the first time in Swangard 1, which was served on the 31st of December. Before that, and my lordship, your lordship, I've taken you to the various communications. Before that, the defendant's position was, we're dealing with it, we've disclosed documents, we are engaging with the reformulated request to produce. There was no indication that further production was taking place. There was no indication that 6,000 documents were still being reviewed. And in the middle of all of that, the defendants then, on the 13th of December, indicate their intention to change legal representatives.
Tell me this, in 2820, when is that production, the production statement, or whatever it's called, when is that to be done? Is to be served presumably once document production has come to an end. In other words, you've given what you think you ought to have given.
Well, your lordship, it doesn't categorically say it's when document production comes to an end. The point being that
it'd be bizarre if you said it when you've still got more to give.
Well, they can give a document production statement with regards to the documents already given. I mean, the problem that we have, the claimant has.
I didn't understand that. You say in your production statement you've produced copies of all documents, etc., which have been requested and to which no objection is raised. And at the same time, you can say, but we're still looking to comply with our obligation to produce documents.
Well, your lordship,
you can't do both.
Well, you can qualify it with regards to the documents already produced.
The defendant finished getting the documents.
because, Your Lordship, we're round the corner from a trial. We're staring down the barrel of a trial. Yes, Your Lordship has allowed us permission to apply and come back if there are specific gaps. But the problem being is, Your Lordship, that in this compressed timetable, and the claimant is keen to maintain the trial date and has constantly said is keen to maintain the trial date.
The trial date will be maintained. I can see no reason why it shouldn't be.
And, Your Lordship, within the problem that the claimant has again, and the concern is that already only out of the 3,000 documents that have been produced, only 14% were relevant, and therefore in this further 5,000 documents that are now being reviewed, whether or not, to what extent will they be relevant? And I mean, it may be that this can be short-circuited if my learned friend and the defendants can say that out of all of these 5,000 documents, this percentage or this number of documents are responsive to whatever request that the claimant makes. And at the moment, they're not prepared to do that because that's a request that's already been made to the defendants.
Let's stick to one thing at a time. Can you tell me about the case going back to September 2017?
Your Lordship, at this moment in time, I can't. I'll have to take instructions on that, and I can come back to that.
Now's your chance to tell me.
Well, Your Lordship, the only thing I can say...
Nothing in your pleadings, is there?
There's nothing in the pleaded case, notwithstanding that, Your Lordship, and I say this without any evidence before you, but Mr. Kahlon has referred to being quartered by Mr. Gupta, and whilst the pleaded case talks about meetings per se, it refers to meetings in London, Dubai, and so forth, and India, it may be that this period extends to the courtship that Mr. Kahlon refers to. And so it may be that's the period that covers 1st of September 2017. I can't go any further than that. I don't have any evidence, nor do I have instructions, so I'll have to check that. Notwithstanding that,
I've got to deal with it, and I think on that basis, I can't see any basis for making an order in terms of paragraph 1.
But Your Lordship, what we would say is that the order, it can be amended. We'd argue that if there's clearly a pleaded case from May 2018, and therefore that date range can be reduced from May 2018 to the 6th of September 2018.
May onwards is already covered by 2 to 7 or 8 or 9, and by the statement in the skeleton argument that they've looked for those documents, and within the entire date range from May 2018 to whatever it is, sometime in 2019, I think, 20.
May 2022, my lord.
May 22. 22 or 20?
22. Is that the date of termination? May 22. Yes. 22.
Yeah. Yes. The explanation I've been given is that those have been covered by this slightly different wording, but all the various custodians and relating to the terms of proposed employment, including negotiation and internal consideration. If that's been done, then I can't see any basis for a complaint. I mean, by all means, when you have a chance to look at them all carefully, if you see that there are obvious gaps, you can go back.
Your Lordship, I've got instructions on that point, actually. I mean, in terms of this criticism of the ongoing review, I won't take you to the parts of the witness statement, but if one reads the statement in full, its context, the ongoing review aspect provides context to why the further letters were written to the defendant to seek the KS documents and the DMCC documents. And that's why that reference ongoing review is there. I am being told that the review has been complete. It was completed over a number of days, and it was final on the 13th of December. And it was a complete review, and it was a thorough review. And that's where, Your Lordship, those paragraphs of DK Singh 2 come from, that I've already taken you to.
What I would expect then, I'm not saying this critically, but what I would have expected with the application for specific disclosure would be to say, we've looked at this and it doesn't, there seem to be gaps X, Y, and Z gaps, rather than just a reiteration of the whole request?
Well, Your Lordship, those gaps are set out in Annex 1 of the witness statement, page 57.
Yes, but they're not part of the order you're seeking. For example, take request 2. You haven't been able to show me as yet, and certainly haven't articulated it, any particular gaps in the internal correspondence relating to these various agreements. Now, you may say they haven't given you very much, but can you identify any particular gaps from your analysis of the disclosures given so far?
Well, Your Lordship, that would maybe entail having the whole disclosure of the 3,000 documents before the court. But in terms of the gaps that have been identified, page 57 sets out that out of 186 documents, the defendants have not provided the internal emails that are anticipated to exist, most likely between Mr. Gupta and Ms. Timms, leading to the drafting of the first 5th of September.
Okay, let's take that as an example. Why isn't your request for specific disclosure, I'm not sure I'm using the right term, but don't worry, why isn't your request for specific disclosure focused on that and said there ought to be emails internal between X and Y, and none have been given, and therefore that's what you're seeking?
Well, Your Lordship, because until Mr. Swangard gave his witness statement, it wasn't clear to us what the position of the defendants was. I mean, we kept chasing them we wrote at least 4 letters, Your Lordship, and I've taken you to about 4 letters, wherein we were chasing the defendants to find out what their position was in relation to our reformulated requests. And it's only when we issued the application that Mr. Swangard and the defendants gave their position as to the approach taken, the methodology, and as a result, of course, this application has taken a very different turn. But at the point that we were making the application, it wasn't clear to us. The only thing that was clear to us that this was going to be delayed, given that the defendants wanted to disinstruct DCO and instruct another law firm, Altaminis, and that the concern was that this would derail the timetable. It was also a concern that it would impact expert reports and witness statements. And it was as a result of those concerns that it was considered that the matter ought to be before you, my lordship, so that we could get some clear answers from the defendants and understand exactly what the position is. And the claimant was right in doing so, because it's only now, as a result of Swangard 1, that it's become apparent that the defendants are still reviewing and nearly 6,000 documents. And Your Lordship, before that, the position was, and this was the position taken by Clyde & Co, the previous representatives, in June, that there had been a search conducted for relevant documents, and that it was in progress. And it was only when Clyde & Co was disinstructed that this issue of production came about, with Mr. Connolly's witness statement trying to give the impression that the disclosure would be quite complicated. And we say it's not that complicated. It simply isn't.
I think there's some, if I may say so, I think there's some force in the objection from the defendant, from Mr. Trotter, that simply to re-request under a slightly different wording what you've already requested and what's already been searched for is likely to lead to more loss of time and make it more burdensome than if you had waited until you've actually been through everything, which you now have, you say, and said that there is a particular gap here, which shouldn't exist if the proper search be made, and we think we want an order for those particular things.
But Your Lordship, my instructions are that, and Mr. Singh's witness statement says this, that the production has been gone through. I mean, if Mr. Trotter is now saying that we should wait for the 6,000 odd other documents that they want to review.
You're misunderstanding me. I'm not saying that the analysis hasn't been undertaken and you haven't finished going through the documents. What you haven't done, though, is identify what's missing in your request for an order. You haven't said, I want an order for this, this, and this, because although they've given us most things, they haven't given us X, Y, and Z.
Well, Your Lordship, that is set out at Annex 1 at page 57. They certainly haven't given us the internal emails.
Where's your 57? Annex 1.
Yes, and that's referred to in Sing 1, when he talks about the...
Let's stick to one thing at a time. You want page 57. You're asking for the whole reworded application to be granted.
Well, then, Your Lordship, if you look at the third column,
request too.
if you look at looking at the third column, what we say is out of the 186 documents, the defendants haven't provided the internal emails that are anticipated to exist, most likely between Mr. Gupta and Mr. Timms, and not just the claimant and the defendants, but internal emails of internal personnel, important key personnel, leading to the drafting of the 1st of September contract.
Ms. Ahmed, sorry to talk across you. I understand that, and that seems to me the basis of a properly focused disclosure request. But you haven't requested the order you seek is this massive thing, in respect of A, B, C, and so on. All these documents. You haven't focused on what you want, what you haven't got.
Your Lordship, I see the point that you make, and I go back to the reason why the order is drafted in the way that it is because the defendant's position was simply not clear to us. It only became apparent on the 31st of December when Mr. Swangard put his witness statement. But dealing with your point, Your Lordship, if it means adjourning this application for a short period so we can refine the order, the claimant is more than prepared to do that. But it need not be a big adjournment because it simply follows what Annex 1 is saying. And the third column of Annex 1, which is more detailed, and that is in respect of, let's say, 2 internal emails, furthermore, the draft versions of the various agreements. And so internal emails in relation to all the agreements set out there, and draft versions of the various agreements. And with regards to the other requests, we say these are very limited, and we can deal with the objections that Mr. Trotter makes. But with regards to compromise request 2, if it's a case of refining or redefining or narrowing the order that's being sought, Your Lordship, then my submission is now to you that we invite Your Lordship to make an order to provide internal emails between those individuals relating to these various contracts and any draft versions of the various agreements referred to.
Well, how you make an application to the court is a matter for you, not for me to draft. But all I'm saying is I see force in Mr. Trotter's concern or complaint. Well, leave aside some details, which I'll come back to. I see force in the complaint that simply to get a general order covering the same thing but worded slightly differently would be unduly burdensome and pointless. What you need at this stage is, it seems to me, a focus on what you haven't been given, or you know you haven't been given, and requests for specific disclosure of those documents. For example, what you say, as you say, in the right-hand column on page 57, you haven't had internal emails between Gupta and Timms, for example. If you haven't been given that, and you say it's inconceivable that there wouldn't be any, then that's the time to say it, and you ask for that rather than the whole rephrased initial category.
Well, Your Lordship, maybe I'm seeking your indulgence then, but we are seeking an order in relation to those internal communications. Okay. We are before the court, staring down the barrel of a trial, and we'd invite the court to make that order.
Don't make it so dramatic. You're not staring down the barrel of a trial. There's a trial happening in 2 and a bit months' time. I think the right thing to do, if this is a general point that applies throughout, we haven't gone beyond 2 requests so far. it might be best to you could withdraw the application and issue a new one in due course if so advised, or I could go through and, for example, dismiss compromise request 2, partly on the basis that it goes too far back in time in terms of what's covered by the pleadings, and the rest of it on the basis that there's no reason as at present to believe that there hasn't been compliance. But that's
Your
not
Lordship,
making compliance.
We would argue that the Lordship ought not to take that approach, because it would be we are before the court today, and whilst you may say that I'm being overly dramatic, but there is quite a lot of work to be done in terms of getting this matter ready for trial, and therefore to come back and reformulate requests that are already before the court, Your Lordship. You have what the issue is before you in Annex 1, and the issue is that there are simply no internal emails with regards to these contracts and no draft versions of the contract. And Your Lordship, if it means re-clarifying the order and providing the court with an amended order after this hearing, then of course, Your Lordship, we'd be prepared to do that. But at the moment we are before you, the issues have been quite open and defined since the 24th of December. The defendant knew what the complaint was by virtue of Annex 1, page 57. It's not as if we're taking the defendants by surprise, and therefore, Your Lordship, we'd invite Your Lordship to consider this, and we can, and the claimant can amend its order and narrow it to the specific categories of document that the claimant seeks.
So what are you suggesting?
Your Lordship, what we are suggesting in relation to compromise request 2, that we narrow the request. Part A, I need to take instructions on, but certainly with regards to part B, with regards to those key agreements, that the defendant conducts a reasonable search and confirms by way of a document production statement that reasonable searches have been conducted and comply with
this is in the realm of generality again, which is I don't find particularly helpful. If your more focused point is in the third column, that there should be internal emails between Mr. Gupta and Timms relating to a particular thing.
Yes.
And you say there aren't any. Well, if that's what you say, and you can say there's similar things about others of the 7 custodians named, well, you might be getting somewhere. And no doubt there'll be an answer that, well, you wouldn't expect it, or oh dear, sorry, we overlooked that.
And then put it in a document production statement, and we'd be happy with that approach, Your Lordship.
Well, the starting point is a focused application.
Indeed, Your Lordship, and it would be in relation to compromise request 2 arising out of the third column, which is with regards to all of those documents, the agreements mentioned from B3 to B8, that the defendants provide the internal emails, communications documents.
But you say you've got some internal emails.
No, we've got no internal emails. We've simply got no internal emails.
Right.
With regards to the negotiation, finalisation, creation of these agreements, no, do we have the draft versions of the agreements?
Yeah.
And in terms of the custodian and the documents, rather the people, we provided those at the end, being Mr. Gupta, Ms. Timms, Alok Jain. Alok Jain was the HR person in Dubai. Mr. Naval Kishore Marwa was a recruitment consultant. He was engaged, as I understand, by Mr. Gupta to find somebody to fill the role that the claimant eventually filled. And in that context, I've just been handed a note, Your Lordship, and that is the reason why the date range is said to be from September 2017.
Yeah. Is
I beg your pardon, that may have been misunderstood by me. Let me just clarify what that note says. I beg your pardon, my apologies for that. Going back to the custodians, Marwa was the recruitment consultant engaged by Mr. Gupta, and Miss Hayward and Mr. Allen, as I understand, were HR personnel too. And what we're saying is internal emails relating to these custodians that deal with the agreements, the negotiations of these agreements,
Okay.
the drafting of the agreements, the creation of the various agreements, and the draft versions of the agreements.
And as I understand it, the defendant's search of those 7 custodians for matters relating to terms of proposed employment has been carried out. So the best you could do, surely, in this context, as regards B anyway, would be a, what's it called?
Document production statement.
A document production statement. I don't suppose anyone minds doing that.
If the defendants are saying that they've conducted a reasonable search of documents relating to that specific and narrow request, then the document production statement is an obligation to the rules in any event.
Yeah. Okay. Well, then that will happen. Right. Well, at the moment, apart from anticipating a document production statement in due course, I can't see any basis on which I can make the order in compromise request 2.
What the order that we would invite your lordship to make is to provide a timing and a deadline for that document production statement.
Well, the timing is automatic, isn't it? Within the time ordered by the court. Well, we can deal with the timing at the end.
Mr. Swangard says that the searches in his witness statement ought to be complete within 2 weeks of the date of his witness statement, and that was the 31st. And so by the 14th of January, we say that the defendants ought to be in a position to provide their document production statement.
Okay, we'll come back to timing on that, but I can't imagine there'll be too much difficulty about that. Am I wrong, Mr. Trotter?
No, my lord, we've said in terms that we will, of course, provide a document production statement when, as your lordship observed, our document production is complete. Now, of course, it's unfortunate that document production is stretched on. Both parties have missed the deadline imposed by your lordship last time. But we don't cover with that. We say so in terms in our evidence and skeleton argument that the document production statement will be provided in due course in the usual way.
Yeah, okay. Right. Where are we?
Compromise request 4, your lordship.
Yeah.
So this is documents and communications between the 1st of May 2018, and I take the point about the 1st of May 2018. Obviously, that's too expansive, and so right. Your lordship. Oh, no, I beg your pardon. No, it's not. Sorry, I beg your pardon.
September 2017, that was too expensive.
Yes, of course. Yes, my lordships. My apologies for that. 1st of May 2018 to the 9th of May 2022, relating to the financial and/or performance metrics to which the claimant and/or the LTIP were subject. And your lordship, these requests are directly tied to the amended particulars of claim, specifically paragraph 14 of the amended particulars of claim. And your lordship, unless you want me to take you to the document, I do have one eye on the time. I can repeat the paragraphs to you. It's paragraph 14 of the amended particulars of claim, which explains that the LTIP was a key reason for the claimant joining Liberty Steel Group, compensating him for forfeited ArcelorMittal stock options. ArcelorMittal was his former employer. Paragraph 15 of the APOC highlights the EBITDA growth as the primary performance metric tied to the LTIP.
I don't think I'm not sure to what extent this is really opposed. Have I misunderstood the defendant's objection column on page 21?
Oh, sorry, my lord, page 21.
Sorry, of the bundle. It's part of the schedule, probably called Annex 1 for all I know.
Yes, my lord. So I'm not going to make
Your
some
lordship,
I've already cut across my learned friend, but just to explain the table, if one goes 4 columns from the right rather.
Reasons for the defendant's objection.
Yes, that's right. Those are the reasons which we gave on the 27th of September to the request as originally formulated. Now, I'll go into this in due course, but in broad terms, our position is, insofar as relevant, this is another case where it's just swept up by the review for the terms of the claimant's employment, because this is just one of those terms.
But it's covered by what we've been discussing already.
Yeah, this is exactly the same territory that we've been in so far. But we did have some concern that that the terms of the request went further and requested a general search for documents in relation to EBITDA and metrics in general within the whole business. But my learned friend helpfully confirmed in her skeleton argument that that's not sought. So the complete answer to this one is exactly the same point as under request 2. It's already been dealt with.
Okay, thank you very much, Ms. Ahmed. I think that's helpful. It's the same point, isn't it?
The document production statement, yes.
So one would leave it, not make any specific order for the disclosure itself, but assume it will be covered by the document production statement.
Yes.
All right. Then should we go to?
And furthermore, just to, again, my learned friend says that further such documents will be produced in the forthcoming final tranche, which should be completed, as Mr. Swangard says, within 7 days. And so, indeed, the point is about the document production statement and the requirement of it.
Okay.
My lord, I just want to clarify this point that's being made about the document production statement. The document production statement will do what those documents always do. It will set out the scope of the search that's been conducted, the way in which relevant documents have been found, and it will confirm that the documents have been disclosed. I don't think anything else is being asked of us in that regard, but I just want to make sure that I haven't misunderstood something there.
Your Lordship, the document production statement that's being requested is the one that's set out at 2820.
Yeah, 2820.
There's been a reasonable search for the documents in the defendant's possession, custody and control, as to which no objection is made. And as I understand, there is no objection, because what Mr. Trotter is saying, that this has been swept up in the review process. 2, produce to the other parties all such requested documents which have been identified by such search, as to which no objection is made. 3, provide to the other parties information about his document retention policy and the nature of the searches which have been undertaken. And 4, state that to the best of his knowledge, he has produced copies of all documents in his possession, custody and control, which have been requested and to which no objection is raised. Such statement should be supported by a statement of truth.
Yes, my lord, that's just a recitation of the rules. And so my point about this request is that it is swept up by the request to which no objection has been made, which is request 2A. And so this is the same point that we've been making about a number of requests so far. So that's a helpful clarification.
Yeah, very well. Then 9.
And then, Your Lordship, it's repeated original request 9.
Yeah.
And this is, again, internal communications, minutes, meetings, reports, advice notes, emails concerning the claimant's email to Ms. Timms dated the 10th of February. That's regarding the transfer to the DIFC and subsequent email chain up to the 16th of April. And we see the various requests that are being made there. In response to those requests, only 12 documents have been produced by the defendant. And as I understand, my learned friend's objection is and that's at page 20, is that the request...
21. Are we on 9? Yes. No, sorry.
I beg your pardon, yes. I've got the wrong reference number, page 21, yes.
Yeah, right. As you understand, his objection is what?
They object to the entirety of the request on grounds of relevance, reasonableness, and/or proportionality. And they provide there at 21 their reasons. So this request is objected to in its entirety.
Yeah.
And we say again that this request focuses on internal emails, records of discussions and meeting notes involving key individuals at a time where the claimant was questioning his transfer to Liberty DIFC. And when I say questioning, the email referred to, the 10th of February email referred to, is where the claimant is seeking confirmation of his visa status and his employment status with Liberty DIFC. And with regards to the paragraph numbers of the particulars of claim, which shed more light on this, Your Lordship, if I can invite you to turn at paragraph 61
of
the amended particulars of claim, which is page 153 of the bundle.
Yeah.
And the request is the email chain between the 10th of February regarding his transfer to the DIFC and the subsequent email chain up to the 16th of April. And paragraph 61 is on 10th of February, the claimant contacted Ms. Timms to follow up on the contract of employment given the transfer of the claimant's employment to Liberty DIFC. 15th of February, Ms. Timms responded by inviting the claimant to sign the draft May 2020 contract that had already rejected back in May 2020. Again, there's been no internal emails, documents, minutes disclosed as to the reason why Ms. Timms would have sent the draft May 2020 contract when the claimant had already rejected it. 63, the claimant responded to Ms. Timms on the 16th of February, informing her that the May 2020 contract was not acceptable because of the various reasons that are set out there in subparagraph 63. Ms. Timms responded.
Ms. Ahmed, is this not covered by the same point? You're looking for internal emails and other correspondence relating to a later stage of the claimant's employment. Isn't this covered by what's been said generally in the skeleton argument we've been referring to from time to time? They've searched because they've searched for documents in relating to proposed employment. Doesn't that include transfer to DNC?
Well, Your Lordship, we say it doesn't. Again, we say that that description that my learned friend has attributed to the search terms is, we say, not properly set out. He simply quotes related to and then provides a description of what those search terms are without actually specifying what precise search terms have been applied here. Okay. That's the first point.
Is that point again? Yeah. All right.
And the second point is that this isn't in relation to employment terms per se. It's in relation to the communication, the particular communication of the 10th to the 16th of April 2022. Sorry, the 10th of February to the 16th of April. And what my learned friend says in his skeleton argument at paragraph 32, which is page 700 of the bundle.
Yeah. Paragraph what?
32, just finding my copy of it. there's no justification for ordering an independent and freestanding inquiry. So he doesn't say that this is a search that's been conducted and covered by the related to terms category. Instead, he's saying that the defendants object because they say it's a freestanding inquiry into the events leading to this email several years after the claimant's terms of employment were agreed, and it's merely one communication. But that really undermines the relevance of what we say is this communication, because it's not a freestanding inquiry given the references to the pleaded paragraphs in the particulars of claim. It's a narrowly focused request on internal communications and disclosures around the reasoning behind this email chain, wherein the defendant, through Ms. Timms, isn't responding to, or rather when I say isn't responding, it is really set in a position, the defendant's position, that's relevant to the transfer of the claimant to the DIFC, and therefore it's not a broad, unconstrained inquiry, and they're directly tied to the issues. Because one of the points that the defendant makes, rather the claimant makes in his case, is that this correspondence attempted to alter or minimise their obligations that were set out in the 5th of September letter. And therefore, this correspondence and any internal communications related to it would shed light on what the real position was as to what the defendants thought their obligations were. The first defendant thought its obligations were with respect to the 5th of September letter and all the other contractual agreements. And therefore, Your Lordship, we say that the defendants have not responded or engaged with this request to produce. They're dismissive of the request, and actually we say it's quite relevant to the issues that the court has to determine. This idea that this is years after the terms were agreed, we say undermines again the importance of confirming whether or not what the defendants considered were their obligations and whether or not they intended to adhere to them. There's a further objection made by my learned friend, and that is that one of the emails talks about a call to the lawyer. And what my learned friend seems to suggest is that, well, those documents are privileged. But what my learned friend fails to address is that we're not asking for privileged records. We're asking for non-privileged records surrounding the discussion as to the position and the status of the claimant vis-a-vis the first defendant and the status of the 5th of September letter. And therefore we say that the disclosure is missing internal emails. It's missing the creation and finalization and the draft versions of those emails. It's missing meeting records and the broader communications that refer to this chain of communication.
My lord, unless Ms. Ahmed has anything further.
Yeah, sorry, I was just reading the what you say in your comments. No, carry on. Yes, Ms. Trotter, Mr. Trotter.
Thank you, my lord. It might help just to start by looking at this email. It's in the bundle. It's at page 686, just so we can see what this is all about.
I doubt mine goes as far as that. 686.
That is a pity. I think it is also somewhere else in the bundle. Perhaps someone sitting virtually behind me can help me with that. Anyhow, we can come back to that.
What does the email say in summary?
Broadly, it's an exchange between the claimant and Ms. Timms, where he is saying, look, all I've got is this LOI, which I think means a letter of intent, that refers to LTIP. I'm not comfortable with that.
So it refers to what? LTIP, yeah, okay.
LTIP, the $7 million entitlement that he says is quite agitated about by 2022. He says, I'm not comfortable with that. I want a binding, well, I don't think he used the word binding, but he says, I'd like a contractual annex. I'd like another document initially that contains this very important requirement. And That's more or less what emerges from the paragraphs of the amended particulars of claim to which you were taken before, because I mean, there's a bit of a dispute about how one interprets these emails, but in a sense, they speak for themselves. Now, the email is, of course, very much all about his employment date, because it's an exchange about LTIP being incorporated into another contract or into a contract. And so, as we say in our skeleton argument, this is just another one where it's swept up by the review for proposed terms of employment. And my lord was taken to paragraph 32. Not sure if my lord still has the skeleton, but paragraph 31.
Yeah, I have it.
Immediately above that. My other friend was saying, well, we object to this and we don't say it's already covered, but we say in terms that it's already covered. We say the justification for the request given by my learned friend is to identify internal discussions on the employment status and contractual entitlement. Once again, it's swept up by the search for relevant documents in that 4-year date range.
There's 7 people.
That's right. Now, in a sense, the proof of this pudding is very much in my learned friend's eating, because it's in her own annex at page 58 of the bundle. Where it said at the bottom of that page that in response to repeated original request 9, that we've produced 12 documents. Now, as I've said repeatedly, I don't accept the analysis in this annex, but what that shows is that there are some documents that have been flushed out.
Where's the 12 documents?
Sorry, my lord. Does my lord have page 58?
Yes.
And one sees repeated request, original request 9.
Yep.
And on the far right-hand side,
12.
Okay. 12.
I missed it. Yeah.
And then if one just looks at back at Annex A to the draft order, which is at page 21 of the bundle.
Yeah.
Row 9.
Yeah.
And we see what our position was on this request back in September in the 5th column across. The defendants object to this request in its entirety.
Yeah.
So this is one where we have not conducted a specific search in response to this original request, but we have produced documents that are responsive to it on the claimant's own analysis.
Yeah.
And the reason for that is that they have been swept up in the review for documents relating to the proposed terms of employment, because that's what this email is all about. So it's just another case of a specific sub-request relating to a particular email where my learned friend wants us to embark on a sort of parallel inquiry relating specifically to this email.
If you were... Carry on.
I'm so sorry, my lord, I cut across you.
No, I was simply going to say, on that basis, you could, in your statement, I keep forgetting what it's called.
Document
Production Statement.
Document production statement. Strictly, you wouldn't have to say that in respect of 9, because you have made an objection to the category sought. On the other hand, right. you could say, although we object, it's worth saying that it's covered by the research we've done already in respect of 2 and 4, I think.
Yes, we've said that already in the skeleton argument. There's no reason why it can't be said again in the document production statement. But just so we're clear, the exercise that my learned friend wants us to do is, in addition to generally harvesting documents from all of the relevant custodians and then reviewing all those documents methodically for things that relate to the claimant's employment. She'd like us to conduct a separate exercise of lifting up the floorboards and tracing every email, every meeting, anything that led to or from this particular email chain. And that exercise, we say, is first unnecessary because it will have been caught by what we have done. And second, totally disproportionate to the relevance of this email chain. Now, my little friend says, oh, it's very simple. The IT team can just trace the persons doing this email chain that's been forwarded. But the request is not constrained in that way. If one looks at how it's formulated in row 9, it's extraordinarily broad. And so it's all documents, all internal communications, meeting minutes, reports, advice notes, emails, and other records concerning the claimant's email and the subsequent email chain up to 16th of April. So the first point is that's not a date range that constrains the search. That's just a date range that constrains the email chain. And so she wants us to look for any document that relates to that email chain, either on the way down to that email chain or afterwards. And then there's a list of various things that that's said to include. Just for example, number 4, any records or meetings or communications discussing the matters set out in the email chain.
Yeah.
Now, my little friend said my claimant said in evidence and in skeleton, well, you could just get your IT guys to see where this email was forwarded, but that's not what this request is asking for. It's asking for any time anyone has discussed anything relating to the matters that are set out in that email chain. So if one imagines what the exercise involves, one has to first go to the email chain, create a list of all the matters that are discussed, then one has to embark on some sort of inquiry into, unconstrained by custodians and date ranges, to any communications in relation to that. And put in the context of a disclosure exercise where we're already searching for everything that relates to the terms of employment, which is the thing that's really an issue, we say that exercise is just totally unnecessary.
Yeah.
There was one other discrete point taken about, there should be disclosure of meeting records. I don't have the figures to hand, but there has been a disclosure of a great number of meeting records traversing the entire time period. So if there were such meetings, then they'll be in the disclosure. And again, our document production statement will confirm the searches that we've done for records of meetings. And my learned friend, if she has a specific gap or specific meeting that the claimant thinks is missing, or set of meetings, then there can be an application for that disclosure. But it doesn't begin to justify this kind of roaming request.
Your Lordship, perhaps I deal with that sort of meeting records point. There has been disclosure of certain meetings, but without any context whatsoever. So it's not clear to us what these meetings are for and whether or not they're relevant to the issues. However, I take Mr. Trotter's point, and we can ask questions about any meetings around the time period where these events occurred. The second point, Your Lordship, is this. The claimant is seeking the defendants to really comply with obligations set out by the rules. Namely, and the first one being, what it really wanted is the defendant's position in relation to the reformulator requests. That's what it wanted, and it had asked for those on 4 separate occasions, and I've taken you to the letters. So that's the first point, and now we have those. The second point is the disclosure, the document production statement. And Your Lordship, I hear what you say about that. In terms of the document production statement, Your Lordship, the concerning aspect of, again, and I go back to this point, the concerning aspect of what my learned friend says about the search terms applied. If one looks at the RDC, that talks about parameters of electronic searches. And what that effectively sets out is that the parties should agree in advance the parameters of any search for electronic documents. And if there are any disputes about it, then it should come to court. Now, I accept that there hasn't been any agreement about parameters of those electronic searches. And this is what really the dispute seems to be coming down to. And as I say, I go back to the point that this dispute has only arisen as a result of what Mr. Swangard has said in his witness statement and what Mr. Trotter has submitted both in his written arguments and his oral arguments. But coming back to this point, it is not clear to us the electronic searches that have been undertaken, and therefore what we'd also be seeking as part of the document production statement is what electronic searches have been undertaken, which is envisaged by the rules, Your Lordship, and I refer to 28.23 and 28.24 and 28.25. And it's incorrect of Mr. Trotter to say that I expect him to unearth skeletons from underneath the floorboard. And he didn't say that, but there was some mention of floorboards. That's not what I'm asking the defendant. So that's not what the claimant is asking the defendants to do. The claimant simply wants these categories of documents because they say they are relevant to the disputes, and wants the defendant to confirm, or rather conduct a reasonable search and confirm the nature and adequacy of the search with reference to the rules and provide a document production statement. That's where we've got to, Your Lordship.
Mr. Trotter, I know the rule doesn't in terms put it this way, but would you have any objection in when you produce your statement, which I've forgotten the name of again?
Document production statement.
Document production statement.
Your Lordship, what RDC 2821 does do is says that the factors may be relevant in deciding the reasonable of a search for electronic documents include, but are not limited to, the following: number of documents, nature, complexity of proceedings. These and expense of retrieval includes accessibility, servers, backers, and so. And Your Lordship, you can read that yourself.
Well, what I was going to ask Mr. Trotter was, in providing the document production statement, whether he would be willing to undertake on behalf of his clients that they would include the information relating to what's in 28, 23 and 24. In other words, identifying the parameters of the search, of the electronic search and so on, just so that it avoids further application on the basis we don't know what they've looked for.
Well, my lord, we of course will provide a document production statement that complies with the rules.
Yeah.
Now, yes, I mean, I'm a little bit concerned about this sort of evolving wish list coming from my learned friend about things that she hasn't applied for, that I'm being asked on the hoof to give undertakings on behalf of my client to do. If it's required by the rules, then we will of course do it. And more generally, we will endeavour to be helpful, as we would expect my learned friend's clients to be, in order to facilitate this matter moving forward. But I'm afraid that these matters having been raised for the first time in oral argument, it's very difficult for me to give commitments that particular things will be given in document production statements. So I'm not personally, I'm pleased to say, the one reviewing documents and close to the detail of the exercise of harvesting and reviewing things. So we will comply with our obligations under the rules, and I would resist any attempt to sort of elaborate on that on the hoof and seek relief that is not anywhere to be found in the 819-page bundle and very extensive evidence that we've had to confront over the Christmas period.
Your Lordship, if I may say, the claimant was chasing the defendants for a response. It never got a response until the 31st of December. And it's only just...
Let's not go back over that again.
In which case, Your Lordship, in terms of the parameters, I mean, I hear what Mr. Trotter says, but the regrettable consequence of Mr. Trotter's position is this: that a letter will be written to the defendant seeking what searches or search terms, the parameters of search terms they've applied to electronic documents. They will no doubt then take weeks to respond, and then we'll find ourselves in a position where we're back in front of the court again. And that's simply something that the claimant wants to avoid, both in terms of preparation for trial, both in terms of incurring costs, and also the resources of the court and the parties as well. And if Mr. Trotter's position is, well, we've applied search terms, we've swept up everything, then it can't be that difficult to understand what search terms have been applied. and whether or not those are sufficient.
My lord, that is not a regrettable consequence at all. In fact, it's exactly what should happen and what should have happened. And it's what we have done. We have written to my learned friends' clients seeking details in relation to their disclosure exercise. They have provided details in response, and we have made an application in respect of it. It's perfectly open to my learned friends to do the same thing. Now, I just don't accept that it's appropriate at this juncture for my learned friend to start compiling a wish list of things that she'd like my lord to order be contained within a document production statement for an exercise that's nearing its completion. It's shambolic and shouldn't be allowed.
Well, my lordship, it's in the interest of the overriding objective. We are before the court. We are before the court, your lordship. And again, there is a trial that the parties have to prepare for. And Mr. Trotter's submissions are, we don't object, we have done this, we've swept everything up. Then there should be no real objection as to why the defendants can't provide their search terms that they've applied for their electronic searches.
I've heard you both on that. It seems to me, Mr. Trotter, that although you'll no doubt characterize it as chaotic and so on, that I can include within the order I make an order that your document disclosure statement, document production statement, includes within it an identification of the parameters and so on, which are summarized in 2824. I'm not asking you to consent to that.
I'm sorry, my lord. Could you just give me that rule reference again?
Sorry, when I said 2124, 2824.
2824.
Well, 23 and 24.
Yes.
28, 20.
23 and 24.
Subsection 3 and subsection 4. Is that?
No.
28, 23 and 28, 24. The parameter about dealing with the parameters of electronic search.
I'm sorry, my lord. The whole argument has proceeded on the wrong basis, because I had understood that your lordship was referring to 28.20 sub 3 and sub 4. So that's my misunderstanding. Now, can I just? I should see you. Can I just have a moment to read those rules, please?
Of course, yeah. This is 28.23, 28.24. I know they're applying to a different stage of the process, but we can, as it were, work backwards. And what I suggest to you is that I include, if I can understand why you don't want to give an undertaking, but I could include within the order that a document production statement include details about parameters of search of electronic documents and basically of the type summarized in 28.23 and 28.24.
And your lordship, given we are talking about accessibility of electronic documents.
Let Mr. Trotter finish reading first. I've interrupted him enough.
Sorry, I'm just trying to navigate the scheme of the rules as well, because so 28.20 requires us already to provide a statement supported by a statement of truth that we've produced documents. Now, of course, that document will set out that I don't want to be bound by the wording that I'm coming up with on the hoof here, but the document production statement will naturally set out the nature of the searches that have been conducted to identify those documents. I don't think anyone sitting virtually behind me is that statement.
You're saying that would cover what's in 28.23 and 28.24.
Yes.
In other words,
I'm just waiting for some instructions on that. But in a sense, I think this is a bit of a storm in a teacup, because of course the document production statement will say what we've done.
Yeah,
that's what these statements do. So I'm not sure.
If it doesn't, there can be a further application.
Yes, and I think there's even a template for these things that set out. So I'm not sure this is really controversial. Okay. Being told that, yeah. So, and if there's, I mean, there have been, for instance, disputes about the sufficiency of my learned friend's document production statement. I'm not getting into the mudslinging my Lord wanted to avoid, but by way of the illustration, we have made an application to remedy those, and perfectly open to my learned friends to do the same thing.
Yeah. Okay.
Your Lordship, may I have an opportunity to reply? 28.20, looking at the scheme, 28.23 is the nature of the searches. 28.21 then lists out the factors that may be relevant in deciding the reasonable of a search, and that sets out 1, 2, 3, and point 3 there talks about electronic documents, accessibility, and so forth. And therefore, if that's not included in the document production statement, it'd be very difficult for the claimant to assess the reasonableness of the search and the adequacy of the search. Then 28.23 are the parameters of any search, including the electronic databases to be searched. Now that ties in with 28.21, the search terms to be used. And Your Lordship, that's where the contention is, because from what my learned friend has just said today, or yesterday, in his skeleton argument, that the search terms were related to quote unquote provisions or terms of the employment, it's not clear to us the specific search terms that have been applied, and therefore compliance with 28.23 is sought. And Your Lordship, the claimant is invited for you to make that part of the order.
I'm so sorry.
I think stop. I think we're getting drawn too much down the road of making things up on the hoof. I'm going to row back from where we were and simply leave it. The document production statement will say what it says. If it's inadequate, there can be an application.
Thank you, my lord. Can I just clarify one thing? This is meant to be helpful to my learned friend, because I think there's been a misunderstanding about the quotes in my skeleton argument. The words relating to in quotes are not the quote of a search term that has been applied. They are a quote from our formulation of the issue under issue 2. So that this whole issue about search terms, I think, is a bit of a red herring. But anyhow,
is Mr. Trotter volunteering the search terms then? Just to be clear.
No. But you'll get what you get, and if it's not good enough, you can complain. Right. It seems to me that 9 is dealt with by saying it's covered by the same, whether opposed or not. It is covered by what has apparently been done in relation to the other requests we've been talking about already.
Well, Your Lordship, we are now at compromise request 10, and that deals with documents relating to the establishment of Liberty DIFC. So it's not specifically about the terms of employment, it's more about Liberty DIFC, the transfer of employees from DMCC to DIFC, and the treatment of the transfer of those claimants' employment rights pursuant to the transfer from Liberty DMCC to Liberty DIFC. So that's compromise.
What is this? What I've forgotten now the subject matter of this particular point.
So the point is, Your Lordship, that the 5th of September letter 2019 was entered into between the claimant and Liberty DMCC. Liberty DMCC is an onshore entity. And the claimant's claim is that on or around the 7th of July 2021, there was an oral agreement between him and Gupta that the claimant's employment would transfer to Liberty DIFC, and thereafter he worked in and out of Liberty DIFC. And the point there is, and I think that can also be taken with regards to compromise request number 12, as well as the DMCC documents that we've sought, is that the DMCC entity wasn't an operative entity insofar as it wasn't capable of being an employer. And therefore, we say that these documents are relevant, as well as the DMCC documents that are relevant. And I think that's at paragraph 1B of the order. And what we say that this address compromise 10 and 12, if I'm taking them together, and the DMCC documents, just taking them together, address the establishment of the Liberty DIFC and the reasons for its creation. And I've already taken you to the relevant parts of the particulars of claim. The planned and or actual transfer of employees from DMCC to DIFC, the treatment and or transfer of their employment rights during this transition. And we say that the requests there, as well as the DMCC documents, are closely related. Now, it's not clear to me whether or not Mr. Trotter's position is the same with regards to compromise request 10 and 12, but in terms of what's been set out in the documents, page 21 deals with compromise request 10, which is the defendants object to it in its entirety.
Yeah.
And what my learned friend says in his skeleton argument, it's at page 700, paragraph 33.
Yeah.
To 38, is again that these are too broad. In substance, it's that they're too broad. They go further than the issues, and there is a wide-ranging inquiry. And we say that they are relevant and material to the issues because they're important to understand why Liberty DIFC was set up. The claimant's claim, and is pleaded in his amended particulars of claim, is that Liberty DIFC was set up as the international headquarters of GFG. It was intended, and the decision was made, to transfer all employees to the Liberty DIFC entity, and it was part of a centralised restructuring strategy directed by GFG Alliance, and therefore, Your Lordship, it corroborates really these documents we say would corroborate the oral agreement that we say was reached between Gupta and the claimant in terms of the broader operational and strategic decision making as to the setup of the DIFC. In terms of the DMCC documents, I'm just going to quickly deal with those here. We say that these documents supplement request 10 because what we say is that the financial statements, regulatory filings and utility bills, and that's what we've asked for in relation to the DMCC entity, is essential for determining whether...
Sorry, this is request 12, is it the one?
No, so the DMCC documents is a specific production request, which we've made separately in a letter. I can take you to the letter very quickly again.
I just want to know where I was, yeah.
Yeah, but yes, Your Lordship, I'm dealing with them because we say that the DMCC documents that we seek complement compromise request 10 and 12. And what we seek is in the order at 1B at page 13
of the bundle.
Which is conduct a reasonable search for and produce the following classes of documents: audited financial statements for Liberty at DMCC, utility bills, records of employees, obviously with redactions to address any confidentiality concerns that my learned friend may have. And the reason why we say these are important is to determine whether Liberty DMCC functioned and could have functioned as an active employer after July 2021, or whether operationally, even though it might still be incorporated, operationally, whether or not it became redundant once Liberty DIFC was established. Furthermore, we say that the transfer records of the employees and financial documents will also clarify whether DMCC was functioning operational entity, continuing to meet its obligations to the regulatory authorities, and whether or not, and we say these documents will also establish whether Liberty DMCC complied with its statutory obligations such as licensing and reporting requirements. And all of this is sought because it bears some legitimacy as to who the relevant employer was at the relevant period of time. Was it Liberty DMCC? Was it capable of being the relevant employer at the DMCC? Was there a strategic decision to move everybody out of Liberty DMCC into the DIFC, as the claimant states? And so this is why these documents are sought.
All right. Mr. Trotter.
Sorry, thank you, my lord. Can I break down this request because there are different parts to it and different considerations apply? So if we have a look at it at page 21 of the annex, of the bundle rather, which is the annex.
Yeah.
So we have towards the bottom of that page, request number 10.
Yeah.
And on the far right-hand side, it's been reformulated. And
compromise request 10.
That's right, yes. So 1, documents relating to the establishment of Liberty DIFC and the reasons for establishing it. 2, the planned or actual transfer of employees from one to the other. And 3, the treatment or transfer of the claimant's own employment rights. This one is about the claimant, pursuant to a transfer from Liberty DMCC to DIFC.
Yeah.
Can I take the low-hanging fruit first, I think? Request 10.3.
Yeah.
This one, unlike the other 2, is about the claimant, and we say it has already been dealt with by the existing searches.
The same ones we've been talking about before.
We're now into slightly different territory, my lord will be relieved to know, but covered by different searches, so I'll come to those in a moment. The first thing I'd like to do is just show my lord what the specific issue is on the pleadings about this, because the whole thing gets rather expansive. One can see on the same page there, the issues are summarised in the column with our objections. So when we objected to this request, we say, 1, the issue between the parties is whether the claimant was employed by Liberty DMCC or DIFC from the 7th of July, 2021. There's common ground that he was employed by DMCC before that. The claimant's position is that he was transferred on or from that date. That turns on the claimant's case, and the case is put in 2 different ways. First, an oral agreement between the claimant and Mr. Gupta, said to have been reached on that day. And second, be an agreement arising from conduct thereafter. Now, the oral agreement, in a sense, speaks for itself. The agreement by conduct might require a little bit further explanation. We see that in the amended particulars of claim at page 144 of the bundle.
Yeah.
It's at paragraph 30. So does my lord have that?
Yeah.
So this is the alternative case. It said that there's a contract that has arisen by conduct that Liberty DIFC would employ the claimant on the basis of the terms of employment as defined. So it's the same terms of employment said to have been carried over to Liberty DIFC. And then how is that said to arise? Well, we see that at subparagraphs 30.1 and 30.2. 30.1, the claimant continued to work in the same role, Global Primary Steel CEO, which is at all times a role within the DIFC office. He was provided with a key card, fingerprint, facial recognition access. He was provided with access to a desk. And then 30.2, again, Liberty DIFC provided the claimant with access to its offices and designated office space. So the agreement by conduct is said to arise because of access to the physical office, basically, in terms. So it's actually quite a specific issue about how access was being granted to the physical DIFC offices. In fact, it's even narrower because if we look at the defence, at page 177, we see that actually quite a lot of this is common ground. So if we look in particular at paragraph 30.2, we see this, so this is the pleading back to those two subparagraphs. So 30.2.1, given the scope of his role, he was permitted to work at the DIFC office and did so from time to time. 30.2.2, it's admitted that he performed a role within the wider Liberty Steel group, and further that he had individuals reporting to him who were employed by the first defendant. So it's common ground that he has reports who are at Liberty DIFC. 3, it's also common ground that he had an access card and was set up to access the office with fingerprint and facial recognition.
Which paragraph are you on now?
That's 30.2.3, just the next subparagraph down at the end, bottom of the page.
Sorry.
I'm so sorry. It's paragraph 30.2.3.
My 30.2 then goes on to 31.
Is my lord at page 177 of the bundle?
No, sorry.
So sorry.
It was my fault. I thought I typed it incorrectly. Yeah, okay.
So just to recap then, we have 30.2 just below the middle of the page.
Yeah.
It says in respect to paragraphs 30.1 and 30.2. So this is pleading back to the allegations about access to the office and so on.
Yeah.
So we've got sub 1. It's common ground that he was permitted to work at the DIFC office and that he did so from time to time.
Yeah.
Sub 2, it's admitted that he played a role within the wider group and that he had subordinates reporting to him at Liberty DIFC.
Yeah.
3, he was given an access card. He was set up with access to the office and fingerprint and facial recognition.
Yeah.
4, it's denied that he had a designated office space.
Yeah.
So my lord will have picked up on the way through there that effectively the facts are agreed, but then the reasons for these facts are disputed. So it said, well, for instance, he had an access card, but that was given to all employees of the GFG Alliance in Dubai, irrespective of who employed them. So it doesn't actually take you any further in establishing this contract by conduct. But
Yeah.
the factual dispute here is extremely narrow because it effectively descends to, well, was the office space designated or not? Now, the two issues, oral agreement and allocation of office space, are already dealt with by specific, separate, agreed issues or counter-proposed issues. And first, if we go to page 19 of the bundle,
Yeah.
we're back into request 2 here, but now we're looking at our reformulation, not request 2A, request 2B. So communications relating to the transfer of the claimant's employment from Liberty to Liberty DIFC. So here we're distilling an issue relating to the transfer. And again, the same observations I've made previously apply in relation to issue 2 generally. We've harvested and reviewed the documents across the whole relevant period, internal and external communications from all of the custodians that my learned friend wants. So that's the oral agreement point. Then the access to the officers point, we have a separate issue. And that's if one looks at page 22 of the bundle. Request 12. And we see the defendant's proposed alternative formulation in the middle of the page. records from July 2021 through to May 2022 in relation to the allocation of office space and the attendance at office space. In a sense, the attendance is common ground, but we've offered it anyway. And the allocation issue, which we saw in the pleadings before, is squarely there. So if we then...
I see your proposed formulation is picked up by the compromise request.
Yes. Yes.
In the same terms.
That's precisely right. There's a separate dispute about this issue, and we'll come on to that in a moment. But while we're here, it's right to note that that has been picked up in precisely the same terms in compromise request 1A and 1B, except for the reference to team and DMCC. We can come back to that.
Oh, is that right?
But just on sticking with request 10 for the moment, if we then go back to look again at request 10, compromise request 10.3, which is just on the previous page.
Yeah.
We look again at what they're asking for. So the treatment and/or transfer of the claimant's employment rights pursuant to a transfer of employment from DMCC to DIFC. Now, the only respect in which it is pleaded that such a transfer took place was through the oral agreement and the agreement by conduct that I've just taken your lordship to. And there are specific tailored issues directed to those questions. And so insofar as relevant, this request is captured. Now, it's not clear. I'm sorry?
You say it adds nothing to the other bits?
Yes. Yes, it adds nothing. It's not really clear to me whether textually it is even intended to add anything further. But if it does, then it's outside the pleaded case. So that's already captured. That's the point about that one. The more difficult question, well, I don't say it's particularly difficult, but the different territory is requests 10, 1 and 2, because these ones do go further and they concern not only the claimant, but the operation of the group in general. And we do oppose these on the basis of relevance and proportionality. So I'll deal with them one by one. Starting with request 10.1, this relates to the establishment of Liberty DIFC and the reasons for doing so.
Yeah.
Now, again, the reason for establishing Liberty DIFC is substantially common ground. If we go to the amended particulars of claim at 142, page 142, paragraph 27.
Yeah.
So Liberty, it gives the date when Liberty DIFC was incorporated. It's in light of serious difficulties facing the group, Mr. Gupta at the time, collapse of Greensill Bank. Mr. Gupta saw the DIFC as a credible alternative headquarters, given the quality of the jurisdiction. There's then a sentence about jurisdiction, which doesn't matter to us anymore. End of the paragraph. The intention of Mr. Gupta in incorporating Liberty DIFC was to consolidate the management operations of Liberty Steel Group, decanting its existing staff into the new offices.
Yeah.
Now, if we look at the defence, page 176, at paragraph 27,
yeah,
just conveniently pleading back to the same, also to paragraph 27. The first sentence is denied. That's the bit about Greensill. The move of operations was not primarily related to the collapse of Greensill Bank.
Yeah.
But the rest of it is admitted.
Yeah.
So the only contention here is about the collapse of Greensill Bank. Now, if we just go back to the request as formulated back at page 21
Yeah.
And if we look just at the far left-hand column, and we're here looking at how the original request by my learned friends was formulated. And there's a very long list of things that they're asking for, but specifically I want to draw attention to sub 1A, where they've asked for any considerations, documents relating to the move, and in particular, any considerations regarding the collapse of Greensill Bank.
Yeah.
Now, we said in response to that, that is a complete sideshow. My lord will be familiar with what a saga that has been in the amount of litigation it has spawned, and we don't want to introduce that entire dispute into this trial. In response, my learned friend in her skeleton argument at paragraph 62.4 of the annex.
Oh, right. Yeah, hang on. 62.4.
62. It's on, oh, I'm sorry, this document doesn't have internal page numbers. For my learned friend's benefit, it's page 679 of the bundle.
Yeah, I've got it. 62.4.
62.4. The request does not require the defendants to disclose documents about unrelated matters such as Greensill Bank. So that has now been disavowed. That is not being sought. And then, as we saw it previously was in the document we just looked at. And then paragraph 63, 4 lines down, while the general purpose of Liberty DIFC's incorporation may be common ground, and then continues on. So, my lord, drawing all of that together, what that means is that there is no pleaded dispute that requires a fishing expedition into the reasons for establishing Liberty DIFC, because the only pleaded dispute was about the collapse of Greensill Bank. It's now common ground that that's not fertile territory for disclosure in these proceedings. And so there is simply nothing else to explore. Now, in those circumstances, we are very concerned about the terms of this request and its unconstrained nature, because it's not constrained by custodian. It's not only the decision to establish DIFC, but the reasons for doing so. And one gets a sense of, if it's not Greensill Bank, the various other matters that my learned friend might have in mind from the original request. So if we look at, again, at page 21.
Yeah.
On the far left-hand column.
Yeah.
We have this extensive shopping list that goes over the page. So internal communicate. So A is struck out. They don't want that anymore. Now B, internal communications and meeting notes relating to the decision, strategic planning documents. C, regulatory advice received regarding the establishment. D, applications to regulatory bodies for setting up a company. E, applications made to banks for opening bank accounts. Correspondence with regulatory authorities regarding those applications. Responses and approvals from regulatory bodies. And it just goes on like this. So it's a full excavation into all of the internal workings in relation to the establishment of an entity, when the fact is there's just not an issue about this that needs to be resolved at trial. It's a very substantial and unconstrained request. And again, the prize, if any, is not worth the candle. So that's request 10.1. Then we come to request 10.2. On the same page, back on the right-hand side in red. And now we're talking about the planned or actual transfer of employees employed by Liberty DMCC to Liberty DIFC.
Mm-hmm.
So we're talking about a search for documents relating to all employees of Liberty DMCC. My lord, there is no pleaded issue regarding any other employees. My learned friend has made reference in her skeleton argument, and I think again this morning or this afternoon, to some sort of general scheme to transfer people. That's not the way the case is pleaded. It's not constrained by custodians. But if we see the justification that is marshalled for this request, it's in the far right-hand column of the same page. And it's the email that's quoted. The claimant refers to the email of Julie Duffy to Xenia Femina, dated 7th of July 2021, in which she says, "We're transferring your visa internally another company visa slot." Now, it's not really clear what that means. It doesn't refer to Liberty DIFC. It doesn't even refer to a transfer of her employment. I don't myself understand what a visa slot is. But even if that did have something to do with the transfer of someone else from Liberty MCC to Liberty DIFC, it's a very thin wedge to leave her open an inquiry into all of the other employees in the group. So again, this is one where the relevance just does not justify the exercise. We have, yes, this arises in relation to the DMCC documents as well, but my instructions are that there are 32 such employees, of whom 4 have left the defendant's employment. So we're being asked to produce these records or correspondence in relation to people who are or are previously employed by one of the companies, trespassing on the information relating to unrelated parties. And I just don't see the benefit that the court is going to gain from at trial from these documents. So we say these are fishing expeditions that ought not to be entertained.
Isn't it? It's difficult sometimes when a thing is not technically disputed, but you need a bit more flesh on it in order to understand the possible implications that arise from the agreed circumstances. And I wonder whether this is both in terms of 10.1, the establishment of Liberty DFC, and the reasons for doing so, and also the planned actual transfer of employees, whether that is legitimate to ask for that. Subject to your point, I'll come back to in a moment about the amount of documentation. I wonder whether it would be a legitimate line of inquiry to flesh out the relationship from which it is then sought to be inferred that there was a transfer. Sorry, badly expressed, but you know what I mean. And I wonder whether, if in respect of your concern, but that item 2, with 30-odd employees, whether there could be some more generic thing that simply looked at the internal decision-making concerning the transfer of those employees without necessarily seeking all their employment records.
Well, again, my lord, I think we're into the territory of a properly formulated and more targeted request in the light of the material that's been produced. And the request as formulated is extremely broad, and it may be that there is a more proportionate and more targeted set of records that my learned friend wishes to apply for on reflection, together with any other further requests she wishes to make. And that would, in my submission, be most appropriately done after the final tranche of disclosure has been given in a week's time. But in terms of if my learned friend is going to try and narrow or reformulate the request again now, then, well, I mean, I'll have to see what she has to say, but it places us in some difficulty because we've come here to answer the application that's been made against us. And if there is a specific set of documents that she thinks would be helpful, then we really ought to have the opportunity to make inquiries about the availability of those documents and how difficult it would be to get them. And that's the sort of inquiry we would make if a request of that kind had been made.
I can see that there might be a reformulation of 2, which is about the employees, which might narrow it. But in terms of 1, I can't quite see what the difficulty is about giving disclosure of documents relating to the establishment of Liberty DIFC. I have noted your point about Greensill Bank, but apart from that, in general terms, isn't it legitimate to look at the circumstances or the intentions surrounding the establishment of DIFC?
Well, the difficulty is that they're not just seeking a specific set of readily identifiable documents that will all be in a neat folder somewhere, like the incorporation certificates and so on, nor are they requesting a particular constrained set of communications between particular individuals. On the contrary, what we've got is it appears to be for a range of advice, regulatory advice, applications made to banks, so on and so forth. It's a very expansive request. In fact, it's not even constrained to searching for communications. It seems to suggest that one would need to rifle through the records of the companies and fish out any applications or advice that have been sought and so on. It's quite a potentially big job. Now, it might be that...
Sorry, Karen.
I'm so sorry. It might be that there is some more proportionate, more targeted formulation that my learned friend could come up with. And I've no objection to her going away and doing that. And if it's sent to us in correspondence, we'll engage with it. And we'll make inquiries about what could be done, what could be sensibly produced, and endeavour to agree the matter. But it's very difficult to do it on the hoof now when the people who will need to actually get into the weeds of this, thrash through the undergrowth, can't tell me what the position is.
Okay. Well, just before I go back to Ms. Ahmed about this, I'm very conscious of time. We've kept the court staff for 5 hours nearly, instead of 2 hours, and they haven't had a break. It's also getting to the end of the DIFC working day. And we're going to be another hour, I'd have thought, at least on this. Are either of you, sorry, both of you available for an hour tomorrow?
Yes, Your Lordship, I think I'm available. I'll just double check that, but I think I will be available, yes.
I should ask the court whether they're... Alia, do you know whether it would be possible to continue this tomorrow morning?
Yes, Your Lordship, the court is available.
So I should apologise, Alia, for keeping you well beyond
Not at all.
your engaged time.
Not at all, that's all right.
Mr. Trotter, are you available tomorrow morning?
My lord, yes, I think so. Yes, my lord, I'm not sure what Your Lordship had in mind. We're sort of halfway through a request now. might be sensible
Well,
to try and deal with that.
it seemed actually quite a convenient point to allow Ms. Armour to take account of what you've said. Perhaps before we meet, to consider whether she wants to reformulate it in a narrower way, which will give her what she wants, but without disappeared now, Mr. Trotter. Oh, there you are.
Am I back? Sorry about that. Well, my lord, we're of course happy to be constructive. My intention was not necessarily that she would reformulate something on the hoof, but if
definitely wouldn't be on the hoof if it had overnight.
Yes, well, it depends a bit on what time of night, I suppose, and how far we can get instructions, but we'll do our best.
My lordship, can I just sort of say one point about the reformulation? Because it's not clear to me why my learned friend is saying it's so expansive, and it may be that he can clarify that, because the compromise request is set out at page 21, refers to all communications and documents and a date range. Now, those documents...
It's a year and a half. A year and a half, no, 2 years and a half. Sorry, 1 year and a half date range.
And so it would be a narrowing of that date range. I can see that. Yes.
That'd be one aspect. All documents relating to the establishment of DIFC and the reasons for doing so. Well, how far do you go? I suppose, do you want to identify some individuals in whose possession they may be, or between whom and whom they may have been exchanged? And the planned and actual transfer of employees. I take Mr. Trotter's point about there being 30-something employees. Do you want all their whole employment files? And it's a bit invasive, quite apart from the work involved. What you're really looking for is some decision as to the method of their transfer and the consequences in terms of employment and things associated with that, I presume.
Yes, the decision making around it. Yes, we don't want their whole HR record.
Yeah, and the explanation given to them as to what is happening to them. Are they changing companies or just changing locations, or that's the sort of thing you're after, isn't it?
Yes, it is, Your Lordship. That's exactly right. Yes.
So, and you might want to look at the whole of compromise request 10 in that light, and also 12, I think, covers similar sort of areas. And it might be that you could even email Mr. Trotter a proposed modification of your request in time for him to consider it, take instructions on it, and be ready to chat about it tomorrow morning.
Yes, Your Lordship. I hope we can. We'll endeavour to do so. Would be a better response.
We'll certainly endeavour to be helpful, my lord. I just want to clarify, though, that I don't take this to be an invitation to reopen or reformulate a series of all of the requests that we've already visited.
No, this is something that I think can or might helpfully be narrowed in the course of discussion in a more focused way than the previous ones.
Thank you, my lord.
How long will we need tomorrow? An hour and a half?
It depends a bit on how far. I sense that really the main points that remain in dispute after this are request 13. There's a bit in that, including a confidentiality point. And then I don't get the sense that there's really a lot in request 14 and 15, because they're in substance reflect what has already been offered, or in one case actually formulated by us.
Yeah.
And so it's already the subject of the exercise that's been going on for months. There's then an issue about what's been called the KS documents, inspection and so on.
Yeah.
Your Lordship, that can be dealt with very, very quickly, and it might sort of short circuit events. I mean, what we wanted was the KS email, the metadata of it in native form, and the provenance of the attachment to it, which was a WhatsApp chat. The defendants have now come back and say, well, they don't have the WhatsApp chat. They've provided the metadata. And what we seek now is the inspection of the devices on which those documents were held. And yes.
Yeah. Okay, well, that should be relatively short. Let's assume at the worst it's going to be 2 hours. Sorry, at the most prolonged it's going to be 2 hours, but hope we can finish it quicker than that. So we'll adjourn at this stage. Alio, if we can stop now and resume at 9 o'clock UK time, which would be
1 p.m.
1 o'clock Dubai time tomorrow.
Yes, Your Lordship, I'll list that.
Thank you very much.
Thank you.